Satu.
Assalamualaikum warahmatullahi wabarakatuh. May peace be upon us. Good morning, Excellencies, ladies and gentlemen participants. Welcome to the second day of 7 ICCIS. I hope you had good rest last night and ready to start the second day of 7 ICCIS on session 4. And I would like to invite Professor Diana Puspitawati, PhD from Brawijaya University to chair session 4. Professor Diana, the time is yours.
Okay, good morning. Thank you for the introduction. Good morning, distinguished guests, His Excellencies, Chief Justice of Constitutional Court of other countries, colleagues, and fellow scholars. It is my pleasure to welcome you again in the fourth session of the 7th International Constitutional Court International Symposium. In this fourth session, we are privileged to have three insightful presentations. Our first presentation will be delivered by Ms. Murti Ayu Hapsari from Pennsylvania State University, and then followed by Mr. Bimo Fajar Hantoro and Ms. Fatima Azahro from Jenderal Sudirman University. And our third speaker on this fourth session will be Ms. Tria Noviantika, Ms. Andia Musfira, and Mr. Rilo Mamudi from the House of Representatives of the Republic of Indonesia. As for the respondent, we have Dr. Ervina Fuadatul Kilmi and Ibu Fitri Mualidia from Kiai Haji Ahmad Siddiq State Islamic University. And we have Muhammad Ali from Constitutional Court Indonesia, Ms. Murti Ayu Hapsari, also for Pennsylvania State University. Our first speaker will be also the respondent of the second speaker, and Dr. Oliviana Agustin from Constitutional Court of Indonesia, Dr. Sugeng from Universitas Bayangkara, Jakarta, and Dr. Dewi Nurul Safitri from Constitutional Court Indonesia. So each presenter on this session will be the same as yesterday, will be given 15 minutes to deliver their paper. And then following each presentation, we will have two respondents, each allotted 5 minutes to share their reflection and critical remark, and then followed by 5 minutes question and answer session, during which the participants are invited to engage with our speaker. So without further ado, let us begin our session. Now we invite our first presenter, Ms. Murti Ayu Hapsari, to start her presentation. Ms. Murti, the time is yours. Thank you.
Thank you very much, Prof. Diana Puspitawati. Nice to see you. And I think this is the first time we met online. So it's a honor for me to be here, and I will begin my presentation now. I am asking for a request to share a screen right now.
Yes, you may share screen to the committee. Okay.
Yes.
Maybe someone can help with the share screen. Oh, now you are a host.
Oh, yes, I think,
yes.
I think it's, yep. Okay. I think I'm audible now. So, yeah. Thank you everyone for being here, and thank you for the opportunity. My name is Murti Ayu Hapsari. I'm a second-year student from Pennsylvania State University, Dickinson Law. And this is actually the second attempt for me to be here, because last time I was not selected. So I was so happy to be here. So my paper for This occasion is titled The Possibility of Judicial Activism in Incorporating Constitutional Complaint. It is an overview of judicial independence. So I will begin my presentation. Before that, I will have to explain the basic structure of this presentation. I will begin with the introduction, and then I will explain my main thesis, and then followed by three sections of discussion, and then I will conclude it with the last time is the conclusion. So of course, the introduction and the background. So basically what I found here, based on what I've read on all of the published paper on the academia of the justices in constitutional court, I found that it is evident, it is clear that the majority voice, both from the constitutional court, both the justices or the researcher and academia in this country, I mean Indonesia, is in favor in incorporating the constitutional complaint as part of the constitutional power. So I also found that there are three main categories on why they think that it should be incorporated. The first thing, it's based on specific legal needs. So this paper from Nugroho in 2023, for example, it needs for a legal certainty in tax legal cases, and there is other one that is promoting based on the freedom of religion. The second rationale is more of a philosophical arguments. So like it needs to be there for a protection of constitutional right in general. The second one is about to be able to to provide a platform to address injustices or maybe potential injustices. The third one is more the broad way, like a manifestation of substantive rule of law and good governance in specific. And there are also a paper that look at the more empirical way, such as because like in reality, there's already a considerable number of cases that is submitted to the Constitutional Court is already can be classified as a constitutional complaint cases. So basically what I'm trying to say is that based on those papers, they say that it is important for Constitutional Court to incorporate constitutional complaint, and they also can be I can conclude that there are three mechanisms or three ways for them to be able to, for the constitutional complaint to be able to incorporate it into the system. The first one is the formal constitutional amendment, and the second one is by the revision of the Constitutional Court law amendment. I think Professor Palguna, I think he proposed this idea. And the third one is through interpretative constitutional or judicial review. So basically from what I've read and what I understand is that the second one is the safest option, and the second one can be said is the most politically viable. But then my focus would be the third one is the true interpretative constitutional and judicial review. And while this third option might be not supported by a lot of people, but I cannot see that they did not completely disregard the idea. So this brings me to the main thesis of this presentation of my paper, is that I think personally Constitutional Court should proceed with caution when considering the expansion of its authority using the third option, that is through the constitutional interpretation. And basically this presentation is about that. So the first one is I'm going to try to bring your attention on why the Constitutional Court would make sense if it has constitutional complaint as one of its power. Because if we are looking from the history of constitutional court, history of human rights struggle in Indonesia, we can see that the Constitutional Court is a key safeguard or a like a key actor for human rights protection in Indonesia after we know what happened in the past and after a long history of incorporating the human rights clauses and provision in the constitution. And here we are, we have the mechanism of constitutional complaint, which is basically sharing the same idea, which in this case, it is safe to assume that if constitutional complaint were to be implemented in Indonesia, it means that the citizen would have a more comprehensive platform to obtain remedies for any right violation. In this case, I would not say that I propose or I'm against. I'm just making a point that it is makes sense for constitutional court to have constitutional complaint. But then we also have, I also have a second point here. It's about the judicial activism, or we can talk about this later. And the courts allegedly expanded its power. So we know that in Constitution, I would say this is, we can talk about this again, but I would say this is a gap where the court is actually empowered or constitutionally assigned to be empowered to review the laws that the govern itself, including its own structure, procedure, and internal operations. So we also know that several times that the court has used its power to declare limitation to its power unconstitutional several times. I cited at least 3 here. So basically, from what I have found, the court is effectively become the sole interpreter of its own power. So this brings me to another idea, is that the court is the only one that can restrict itself from becoming the most dangerous branch to the power accumulated. Okay. So the term most dangerous branch is actually based from the idea of the US founding father. He said that he is called Alexander Hamilton, which said that the judiciary is the least powerful branch or least dangerous branch. But in this case, it is debatable, but yes, because it then can potentially turn itself a potentially super body. So because in Indonesia, the Constitutional Court employ correct me if I'm wrong, they employ a strong type. Is it a strong type? Strong judicial review, which means that their decision is final and binding. It means, again, there is an absence of mechanism to review or check their decision. Well, the parliament actually can, but it's like a gray area in this case. And they, again, it's debatable, they sometimes overtake the responsibility of the elected branch or policymaker in some cases. And the third one is based on Simon Butt research back in 2020. It's his recent book, actually. It says that the court is criticized for exercising its independence without a proper regard for accountability. So I think he said that after his research, reading a lot of court's decision, and it is his conclusion based on that research. And in this regard, again, I'm going to bring the audience attention to the fact that judicial independence is arguably one side of a coin with judicial accountability. So, yep. It is an inseparable and complementary element to enhance judicial system performance. Judicial independence is not there simply for the benefit of the judges, because their role are supposedly carefully circumscribed or limited by the constitutional system. So that it is important to have an equilibrium or balance between independence and accountability, and it should be essential component as a judiciary as a whole to remain respected. It is important to remain respected because it is closely related to their legitimacy. And of course, as a one of the branch power that is unelected, in this case, legitimacy is something is heavily important. So next one is that, to be honest, my proposal of this main thesis is practically a pragmatic one, because then if court decided to self-expand its authority and including the constitutional complaint by using judicial review or constitutional review, potentially there is a high possibility the resistance from other branches will be there. So, and it will also disturb their independence as well. So yeah, the first thing is that incorporating constitutional complaint using constitutional review could potentially increase resistance from the other branches, and it also can be potentially increase the friction between the branches. And a more theoretical one, it might be potentially breach the separation of power doctrine. And again, it can be also seen as a act of aggression. Maybe aggression is not the right terms in this case, but you get my point. And I think again, failure to exercise restraint and expanding its own power could ultimately result in long-term negative impact on the courts and judicial independence itself. So by then, I have four conclusions. Basically, I want to say that it is important to have a both accountability and restraint in a form of independence. And I just also want to say that the most vital function of the Constitutional Court is as guardian of the Constitution, and it is not by means a substitute for other branches. And the third one is that, of course, if the courts, it is important to have a formal, legitimate process, like in constitutional amendment or legislative revision, not self-interpretation. And I think by demonstrating self-imposed restraint, it is also important for Indonesia constitutional democracy and rule of law. And I think it is also related to Rosalind Dixon's recent book, not really recent, but I think it's called Responsive Judicial Review. I haven't finished reading it, but basically the point that I can get is that it is important for the court to be able to guard the country from democratic instability. But then I think she also think that pragmatism, some degree of pragmatism, it is necessary to be able to bridge between the discussion, or to be able to provide a discussion between legislative parliament and the uh, the judiciary. So that is my presentation. Thank you very much. I'm really looking forward to the response and Q and the question. Thank you very much.
Thank you, Miss Murthy. So as we can notice from the Miss Murthy presentation that she proposed that constitutional complaint can be due by expanding the court jurisdiction by interpretation, but should be proceed with caution, cannot be unilaterally decided by the court. So for the first speaker in this session, I wanna invite Dr. Ervina Fuadatul Hilmi and Miss Fitri Maulidia from Kiai Haji Ahmad Sadiq State Islamic University to deliver the first response. The time is yours.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi.
Yeah. Good morning, the Honorable Professor Diana Puspitawati, PhD, distinguished speakers, participants, and honorable guests, but from Indonesia and abroad. I would like to thank you very much to Ms. Murti Ayutari for such an insightful and thought-provoking presentation. Allow me to share a brief response and perhaps raise a few questions for further discussion. The point one, the article offers an important and distinctive perspective in the discourse on constitutional complaint in Indonesia, where the majority encourage the Constitutional Court to expand its authority progressively through judicial interpretation. But the author takes a more cautious approach, warning of potential dangers of judicial overreach. The author emphasized the importance of judicial restraint, maintain the legitimacy and independence of judiciary. Excessive judicial activism, according to the author, may lead to judicial overreach and bring long-term negative consequences, such as violating the separation of power doctrine and the constitutional court history of activism, whereas expanded its authority beyond constitutional limits seem a legislative legislature to a positive legislature and issue conditional decision. And three, this causing political friction is excessive activism and expression of authority through interpretation could increase tension with other branches of government, thereby threatening judicial independence in the long run. However, the article still tends to be normative. It would be stronger if the author complemented with empirical data. For example, by presenting the number of cases that could potentially fall into the category of constitutional complaint and analyzing the causative factors, one which of the political aspect that often drive the constitutional court toward judicial activism. Such an approach would make the discourse on the institutionalization of constitutional complaints more comprehensive, not only hedging the potential dangers, but also providing an operational picture of how the mechanism would function if were institutionalized. In addition, the article tends to prioritize the establishment of the constitutional complaint system to formal procedure, such as amending 1945 Constitution or revising the Constitutional Court law and emphasize judicial restraint, limiting judge interpretation. However, the efforts look the urgent demand for substantive justice and the essential role of the Constitutional Court as the protector of constitutional rights in Indonesia. Okay, your finding are very insightful. But I have one question for you. How do you see about the political intervention in the should the constitutional court emphasize judicial restraint or judicial activism in developing in authority? Yeah, this is one question for you. Why? Thank you.
Okay, before answering, would you mind if I proceed to I think we should proceed to second respondents, right? Ya, Murti ya. Okay, second respondent, I would like to invite Mr. Muhammad Mahrus Ali. Pak Mahrus, the time is yours, just for 5 minutes. Long time no see ya, Pak Mahrus ya.
Yeah, long time no see. Thank you, Professor Diana, distinguished speakers, all participants of the conference. The article by Ms. Murti Ayu Hapsari is very interesting, and I have some commentaries or respond and also questions to the article.
Enggak, bagus-bagus itu. Kung yang lainnya kemarin jangan gitu ya, mentor yang kali itu
Oh,
wah itu malah lebih.
which one is okay.
Okay, I can proceed.
Yes.
First of all, articles present a balance of legal philosophical discourse grounded in cultural interpretation theory. So I would like to get to make a response in a cultural interpretation perspective, because this is my dissertation project about the cultural interpretation perspective. And I would like to comment about the cultural complaint, the incorporating of cultural complaint in Indonesia. First of all, the article presents a balanced legal philosophical discourse grounded in constitutional interpretation theory, emphasizing that the role of constitutional court should be strictly confined to the constitutional mandate explicitly granted by the 1945 Constitution, and also the article concern against constitutional judicial overreach that might arise if constitutional court expand its jurisdiction uh, through broad judicial interpretation to conclude constitutional complaint without formal constitutional or legislative amendment. I think this is the a classical constitutional interpretation debate between the strict textualism, or we can say originalism interpretation, and also non-originalism interpretation. The argument of judicial restraint aligned with the principle separation of powers and the idea of the expansion of judicial power should be legitimized by democratic process, not judicial authorization. This preserves the court legitimacy and independence by ensuring it does not violate upon the elected branch of authority, which maintain the constitutional balance. On the other hand, the article acknowledges the philosophical and practical imperative of constitutional complaint mechanism to protect individual constitutional right more concretely, especially considering Indonesia's evolving constitutional democracy and human right landscape. This aligns with a living constitutional interpretation approach, emphasizing and the protection of a fundamental rights through judicial activism to fill systematic justice gap. And I would like to propose some questions to this paper. First, how should the constitutional court balance the needs for constitutional development through interpretation with the imperative restraint to respect separation of powers and maintain democratic legitimacy? And then the second, that's the minimalist and somewhat ambiguous language of Article 24C, the 1945 Constitution, and other relevant provisions in Indonesia provide sufficient interpretive authority for the court to incorporate constitutional complaint without formal amendments? Or does it mandate formal legislative or constitutional change? And the third, how could incorporating constitutional complaint through judicial interpretation impact of the court through constitutional judicial interpretation impact the court judicial independence in practical terms, considering political pressure and checks from legislative and executive branch? I think that's all my response and question. Thank you, Professor Diana.
Thank you for Miss Ervina and Ms. Harus Ali. I think we have several questions, yeah, Miss Murti. Miss Ervina suggests that the paper is too normative, should be added by empirical data or empirical fact and look more at the what causes that's this condition. And Miss Ervina also suggests why don't we ask on how the constitutional complaint mechanism rather than establishing new institution. And Mr. Mahrus Ali maybe have three questions. How should constitutional complaint the need for constitutional development, and then how to balance the separation of power while still have the judicial legitimacy, and how could the interpretation impact the court of judicial independence. I think there are several questions for you. Now it's time for you, is it, to answer and respond. Thank you.
Ah, thank you for the response and the question. It is actually pretty complicated
Yeah.
to answer all of that. So, from what I get is that the first question that I get is about what I think about political intervention, and of course about the empirical data and stuff. It's really, I really thankful for the input. It's I will if I have a it's to be honest, I feel that paper still has a lot of room for improvement. So I think I can use that input as well. And about political intervention, to be honest, I don't have much knowledge about that to make a proper comment. So to be honest, about political intervention, I don't think it's my capability to comment on that. And about the question from Pak Muhammad Mahrus, about how it balances and the restraint and the independence to be able to produce some kind of independence. I think it will be, I would, this is the project of my dissertation that is still ongoing. So right now I'm still trying to find the answer to that question. So I'm sorry for not be able to provide with a more comprehensive thing because I'm right now still trying to figuring out things. And I think like here I learned a lot about how the judicial power here back home in Indonesia it's really different. And of course I want to incorporate things that is doable in Indonesia, not only taking things from other country, something like that. So of course the debate about judicial restraint, which is also heavily correlated with the minimalism and such, is important. I mean, it is mm, for me right now because I think a lot of narrative is um, revolving around incorporating constitutional complaint to the constitutional court itself. I just want to offer some kind of different kind of perspective because I think it is important for our democracy to have a nuances and a lot of perspective to be able to progress. So basically that is my main idea to writing this. So yes, thank you for the input. I will take a good note about this and thank you. I will be able to use this for my dissertation. Thank you very much.
Okay, I think I forgot to give the floor question and answer session. Is there any question from the participants? No, I think if there's no other question, I think it is the end of the first paper. Let us applause for Murti. Okay, thank you, Murti and Miss Ervina and Pak Mahrus Ali. Now we're moving on to our next speaker. Our second speaker would be Mr. Bimo Fajar Hantoro and Miss Fatima Azahro from Jenderal Sudirman University. They will deliver a paper entitled Constitutional Thought as Constitutional Complaint, Reconstructing the Governmental Unlawful Act Regulation. I think this is a very interesting paper, yeah, because the concept of thought, I think that's a bit new in Indonesia. So, Mr. Bimo, the time is yours.
Thank you, Dr. Puspitawati, for the opportunity. Please allow us to share our PowerPoint slides. Um, okay. Okay. Thank you, dear fellow speakers and honorable participants. It is such an honor for us to be able to present a paper with the title of Constitutional Thoughts as Constitutional Complaint, Reconstructing Governmental Unlawful Acts Regulations. And so first, I would like to give way to my colleague, Ms. Fatima, to present the first few slides. Ms. Fatima.
Okay. Thank you very much for Mr. Bimo Pajarhantoro for the opportunity. Okay. First of all, in this background, we already conclude that there is a gap in judicial protections in Indonesia right now. That we conclude there is first problem. The first is Indonesia's constitutional court has the authority to review the constitutionality of law, but not concrete in government actions. And in the status quo right now, in the current regulations in Indonesia, the limitations of the constitutional court right now in the Article 24C, paragraph 1 of the 1945 constitutions that have one obligations to examine the constitutionality of law, and in nature the decisions is a declarative and constitutive, not condemnatory, and so it gives this consequently birth the possibility for a remedy in the form of damage or injunctions in the case of a concrete and or imminent constitutional violations. And so with the problem or the vacuum, there is no regulation concrete to government actions. It leaves citizens without a direct judicial remedy when their constitutional rights are violated by state officials. So the crucial one is the remedies like the monetary damage for past harm, an injunction to prevent future harm, are unavailable through the current national review mechanism. So, because of the problem, it creates a significant gap between the constitutional guarantees and their enforcement for the citizen individual in Indonesia. So, with the background that I shared before, the status quo right now, what the conventional proposal and its obstacles in the applications in Indonesia, we already believe that the most commonly proposed solutions is to grant the ZC or the constitutional complaint in constitutional court or M as a new jurisdictions. And this idea, we already know it a similar idea to the system existing right now in the Germany and the South Korea. And however, we believe that this approach will face some challenges because we already know that if we want to change the MCAS law, it should formal amendment to a 1945 constitutions. Why? Because the limitations of the constitutional court authority in the constitutions is close in nature. So it just can be changed by the constitutional amendment only for the expansions of the court jurisdictions, just by amendment, not by court law perubahan dan lain sebagainya. And so we already believe that if we wanna amendment the constitutions, it will face some problem, like it will be complex, so there is so much political will or politically certain process, and so delaying urgently needed protections. And so with the problem that we delivered before, we have a proposal to rethinking how the constitutional interpretation right now in Indonesia. A key reason for focusing only the constitutional court is misconception, ladies and gentlemen, that it is the sole interpreter of the constitutions. We believe that if a constitutional court attribute with the authority of the final interpreter of the constitutions, it no means exclusive. Every state or institutions or the organization are engaged in constitutional interpretation when they are exercising the constitutional authority. So, under this departmentalist view of constitutional interpretations, we believe that even president and the people's representative council or DPR are engaged in constitutional interpretation whenever they are exercised or whenever they are do law-making authority based on law Article 20 in the constitutions. And so the concept of judicial supremacy that the constitutional courts to exercise legitimate constitutional interpretations while leaving the constitutional court with plenary authority as the final interpreter of the constitutions. And so, with this rethinking constitutional interpretations, the constitutional court rules is not the exclusive interpreter one. We believe that still a final arbiter of the constitutional meanings. So, with that rethinking, it giving implications that be our conclusions in this paper is it makes constitutionally possible to other courts to have the obligations or to have a constitutional complaint in their body, like the state of administrative court based on adjudicate claims directly in the constitutions. Why? Because in law number 13 of 2014 on governmental administration, it has the jurisdictions in adjudicating of governmental unlawful act, or in Indonesia there is perbuatan melawan hukum. This framework, we already believe that allow to put the constitutional complaint to the administrative court under the Supreme Court because the first I said before there is perbuatan melawan hukum in Indonesia or under or a governmental unlawful act. So the key advantage is that this can be implemented to the legislative reform, avoiding a constitutional amendment. We put this CC into another court. There is in administrative court. Then we do the amendment of the constitution. There is so much challenging. We face like politically and so on. So the next one will deliver by my partner.
Thank you, Ms. Fatima. Thank you. I would like to proceed on which model we use and why we use it as the inspiration for the reform of our governmental unlawful acts course of action. So we look abroad at the well-established doctrine of constitutional tort in the United States. And in principle, the doctrine of constitutional tort allows individuals to sue government officials directly for constitutional violations. And so under the current setting, there are two causes of action available. The first one being Section 1983 lawsuit, which allows individuals to sue state officials and local government entities. And so historically speaking, it was part of the Ku Klux Klan Act of 1871, which was enacted after the ratification of the 13th and 14th Amendment of the US Constitution. And as a post-Civil War legislation, it was meant to protect the newly emancipated African Americans from constitutional rights violations committed by the states and its officials, especially those southern states which was involved in the rebellion. However, for several decades since its enactment, it lay dormant until the Supreme Court decisions in Monroe v. Pape and Monroe v. Department of Social Services revitalized its potency as a cause of action. Secondly, Bivens lawsuit. So the difference between Section 1983 with Bivens is that Bivens allows individuals to sue federal government officials instead of state officials. And the difference with 1983, Section 1983 lawsuit is that it was implied directly from the US Constitution. So it was not based on any federal statutes. And it was actually an anomaly, especially after Supreme Court decision review Tompkins, which barred the federal courts from creating a general common law remedies. And both cause of action provide two types of relief. The first one being monetary relief in the form of damages to remedy past constitutional violations. And secondly, prospective relief in the form of injunctions or court orders to prevent imminent or future harm. And this dual system offers a powerful model for preventing and remedying constitutional violations. And this concept of constitutional tort is very much similar with the own concept of unrahmata over hibsat, or governmental unlawful acts lawsuit, which currently falls under the jurisdiction of the state administrative courts, post law number 30 of 2014, just the governmental administration law. And the courts are empowered to review government actions that violate, the first one being existing laws and regulations or peraturan perundang-undangan, which is a very broad term, may include the 1945 Constitution. And secondly, the principles of good governance or AUPB. Crucially, the courts already have the authority to order remedies, including damages and injunctions. However, according to our analysis, we diagnosed two fundamental weaknesses of the current framework. The first one being the ambiguous basis for review. While the law textually permits of using the 1945 Constitution as a basis of review, its open textured language creates uncertainty, so it might lead to judicial hesitancy for them to use the Constitution as a basis for review. And the second problem is that there was an inadequate remedy. So there is this government regulation of 1991, which caps the maximum payable damages at 5 million rupiah. So in today's economy, it was a inadequate amount of money to provide meaningful remedy or deter constitutional violations. And so I would like to address a misconception regarding the Supreme Court circular. So there was this SEMA, or Supreme Court circular, which removed the damage cap for factual actions. And we argue that this position is normatively incorrect, in that the governmental administration law already broadened the official definition of state administrative decision to include factual actions. And therefore, the damage cap, which applies to all cases involving such decisions, must legally remains in force until it is formally repealed. And so, with regards to the Part 4 reform, I think there are two essential reforms that needs to be done in order to transform this existing unrahmata over hibsat lawsuit into a robust constitutional remedy. The first one being to clarify the basis of review. This is done by amending the law, especially the law on state administrative court and governmental administration law, to provide for clear and explicit statutory language that removes ambiguity, thus encouraging the courts to confidently apply the 1945 Constitution as a standard of review. And secondly is to abolish the damage cap. So this is done by repealing the government regulation number 43 of 1991, thus allowing the courts to award fair and proportionate damages. And so there might be some risks of conflicting interpretations between the state administrative court and the constitutional court. And so to ensure that there is legal uncertainty and consistency, we propose that there must be some procedural safeguards. The first one being that there needs to be a guarantee administrative courts to give full effect to existing constitutional courts' interpretation of the 1945 Constitution, where available and applicable. Secondly, there needs to be a stay of proceedings at the state administrative courts in case there is a relevant adjudication or depending at the constitutional court. However, there needs to be a limitations as one constitutional court proceeding, which necessarily require the interpretation of one or more constitutional provisions, might implicate too many constitutional complaint cases at once at the state administrative courts. So we propose that the stay be done only in the pending case involves similar constitutional issue. that will directly impact the complaint's legal basis. Secondly, a stay is not required if the Constitutional Court is still in its preliminary examination stage. So there no needs to be a stay if the Constitutional Court is still in its preliminary examination stage. And so, in conclusion, Indonesia could significantly enhance the protection of citizens' constitutional rights through a more practical and targeted reform agenda. And rather than opting for the difficult path of constitutional amendment, the attribution of constitutional complaint authority to the state administrative courts is a more feasible option. I think that's all from me. Ms. Fatima, do you want to add anything to the presentation? Okay. So I think that's all, Ms. Chairwoman.
Thank you.
Thank you. Thank you.
Okay,
Wassalamualaikum
thank you, Mr. Bimo. Such a great presentation that proposed the existing government and unlawful acts mechanism to into a form of constitutional court and emphasizes the removing procedural limit like a damage cap and aligning the mechanism with constitutional interpretation to strengthen the citizen judicial protection. Now, for this presenter, we have two respondents, Ms. Murti Ayu Apsari and Dr. Oliviana Agustin. So each of you will be given 5 minutes to respond to this paper. Now I would like to invite Ms. Murti Ayu Apsari to respond to this paper.
Thank you, Prof. Diana. First of all, I really want to appreciate both of the authors, Mas Bimo and Mbak Fatima. It's a really well-written paper, and I really, really like it. I really enjoy reading it. And I think it's really brilliant for you to be able to offer a solution based on a empirical standpoint. And I think it's really good because you have uh, like bottom-up perspective, like in inductive perspective, and then you craft the solution and the idea based on the existing legal framework in Indonesia. And really, it is the first time I heard about constitutional tort. I know torts because it is a really big thing here in the US, and when I try to look it up, turns out the Department of Justice itself has a division about constitutional tort. So it's really insightful for me too, and I think it's really important again to be able to empower other court other than constitutional court to be able to strengthen or to be able to protect the constitutional right of citizen. So I think it is also a great idea, and I really genuinely want to know one thing. So I have one question for both of you is that like uh, okay, let's say this your idea can be implemented. So right now you have two court that have the same function, that is the constitutional interpretation. You have the state administrative court and constitutional court, both have the power of constitutional interpretation. How do you describe relationship, or how do you describe the correlation between these two, or what do you have on what's on your mind about this? Because I genuinely want to know. Thank you very much, Prof. Diana.
Thank you, Murti. Now we go on the to the our second respondent, Dr. Olivia, Dr. Oliviana. It's nice to see you. Where is Dr. Oli? The time is yours. Dr. Oli. Let me check. Is there Dr. Oli? Okay. The time is your Oli.
Ya, Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam.
Firstly, I would like to say thank you to Professor Diana as a chairwoman in this session, and also the committee who has invited me to join and respond one of the interesting article. I agree with Ms. Murti from the speaker, from the scholar Mr. Bimo and Ms. Fatimah. Nice to meet you and congratulations on your wonderful presentation. Secondly, I would to respond the article by presenter that gives us an interesting idea about how Indonesia can strengthen the protection of citizen constitutional right. And the presenter argued that Indonesia could learn from the constitutional thought concept from the United States and apply it by changing how lawsuits against government action or governmental unlawful act work in the state administrative court. Their main point is the Constitutional Court currently has limited power, so it cannot handle constitutional complaint like in Germany or South Korea. Right now, Constitutional Court can only review laws to see whether they are in line with the Constitution. This power is listed clearly and completely in Article 24C of the Constitution, which means no new power can be added unless the Constitution is amended. Because of this, the presenter suggests a different path. Instead of waiting for a constitutional amendment, which is politically difficult, Indonesia could let state administrative court handle cases that are similar to constitutional complaints. This would be done by adjusting the existing rules about lawsuits against government actions. The idea is to give state administrative court clear legal authority to use the Constitution as a standard when deciding cases where citizen constitutional rights are violated by government officials. State administrative court could then give injunction, order to stop or change government action, or award damages like remedies that the Constitutional Court currently cannot provide. From this point, I have two questions for both of them. Why did the presenter compare Indonesia constitutional complaint system with those of Germany and South Korea? And how do the experiences of Germany and South Korea in implementing constitutional complaint mechanism serve as models or a point of comparison for developing a similar mechanism in Indonesia? And the second, why did the presenter propose the state administrative court as an alternative forum for constitutional complaint instead of the constitutional court? What are the weaknesses of the constitutional court mechanism that the presenters to suggest state administrative court as an alternative forum? Okay, I think it was enough. Maybe any mistake in my words. I apologize you so much. Thank you.
Okay, now I give the floor time to, I just collect the question first. Is there any more question from other participants? I cannot see the raised hand. So we have like three questions, one from Murti and two from Oli. Murti asked how the presenter described the correlation between two courts that having same function related to judicial interpretation, and Dr. Oli have two questions. Why the presenter compares German and South Korea and how they serve as a model on constitutional complaint. And the last question is why state administrative court as an alternative for constitutional complaint. What is the weaknesses of constitutional court so the court cannot handle the constitutional complaint? I think that's the question. Now, Mr. Bimo, can you respond on this?
Thank you, Ms. Chairwoman. So I want to say thank you first to Ms. Murti and Dr. Agustin for the kind response and the brilliant questions. And so for the first question from Ms. Murti, so we start from the departmentalist view of constitutional interpretation, by which not only the Constitutional Court, but rather other state institutions may also interpret the Constitution. And so with regards to the correlation between the Constitutional Court and the state administrative courts, so we propose in our paper several procedural safeguards by which the state administrative courts must give full effect to existing constitutional interpretation from the Constitutional Court. So I think there must be some consistency between the Constitutional Court and the state administrative courts. Also, we must take note that the Constitutional Court is the final interpreter of the Constitution. And so that's why I think um, the state administrative court must give deference to the constitutional court interpretation. And so that's why we also propose the procedure of stay of proceedings, by which the state administrative courts must stop its proceeding in case there are similar pending case at the constitutional court. But as we propose, there must be a limitation because it might implicate too many cases at once at the state administrative court. So there must be a real similarity between the cases in constitutional court and the state administrative court. So that's the answer for Ms. Murthy. And also for Dr. Agustin, I think what you mean is why we compare it with the United States. I think that's the question. And so I was a U.S. law graduate, so that's why I knew a little bit of things about constitutional tort. And when I was studying in the United States, I thought that constitutional tort is a pretty similar concept with governmental unlawful act. And the only difference is that it is pretty rare for state administrative courts to use the 1945 Constitution as a basis of review. So I thought, why should not? So why shouldn't? Right? So that's why we choose the United States as a model. And so that also gives me the inspiration to why we are looking to Germany and South Korea instead of the United States. There's this concept called constitutional tort that is pretty similar in concept, and it also is pretty feasible if you want to adopt it in Indonesia. And the reasons why we attribute the authority to the state administrative court instead of constitutional court, it is because the first thing is that Article 24C is closed in nature. So as compared to Article 24A, paragraph 1, which are open, so it has the phrase wewenang lainnya yang diberikan oleh undang-undang, so other jurisdiction given by law. So we cannot add into the already existing constitutional court jurisdictions. And so the other reasons is that the constitutional court only have 9 justices. And so if you add another jurisdiction to the constitutional court, we argue that it might risk bringing another tsunami of cases into the constitutional court. So that's why we argue that it must be given to the Supreme Court and the state administrative courts instead of constitutional court, because under Article 24A does not limit the number of justices or judges. So it is more a feasible option rather than giving it to the constitutional court. I think that's all from me, Mrs. Chairwoman. Thank you so much for the kind response and the brilliant questions. We turn it to the Ms. Chairwoman. Thank you so much.
Thank you for the response, Mr. Bimo. So Mr. Bimo here is afraid that constitutional court will be overwhelmed if it is given to constitutional court. So we come to the end of this second presenter. Please give applause to our second presenter who introduced a unique, I think unique proposal relating to constitutional complaint. So I should thank the presenter and the respondents. Now we move on our last but not least presenter for this session. The third presenter will be Ms. Tria Noviantika, Ms. Andia Musfira, and Mr. Rilo Pambudi from the House of Representatives of the Republic of Indonesia. They will present the paper entitled Considering the Mechanism of Constitutional Complaint in Strengthening Judicial Activism between the Protection of Human Rights and the Potential Power of Imbalance. So I would like to invite the speakers to present the paper. You are given 15 minutes to present. Thank you.
Okay, thank you for the time. Let me share my screen first. Okay, is it already? Can you see my screen already?
Yes. Yes.
Okay. Oke, Assalamualaikum warahmatullahi wabarakatuh. Shalom, Om Swastiastu, Namo Buddhaya, Distinguished Chair, esteemed college, ladies and gentlemen. My name is Andia Musfira. I'm from Department of Islamic Constitutional Law, Islamic State University, Dato Karama Palu, alongside with other two authors, Ria Noviantika from House of Representatives, and Rilo Pambodi from Department of Constitutional Law, University of Maritime Raja Ali Haji. It is a great honor for us to present before this distinguished audience at the 7th Indonesian Constitutional Court International Symposium to share a few insights on our paper, which lies at the very heart of democratic governance, with the title Considering the Mechanism of Constitutional Complaint in Strengthening Judicial Activism Between the Protection of Human Rights and Potential Power Imbalance. At this time, I will present the first half of the presentation, and then next would be presented by Ms. Ria Noviantika. Okay. As we know, the notion of constitutionalism and the protection of human rights stand as defining feature of modern democracy. In the aftermath of Indonesia's political reform, our nation transitioned from an authoritarian regime towards constitutional democratization, reaffirming the state's duty to safeguard individual rights under the rule of law. A central manifestation of this commitment is the establishment of Indonesian Constitutional Court, entrusted with upholding constitutional justice and preserving the supremacy of the Constitution. However, constitutional issues today extend far beyond the scrutiny of legal norms. The growing discourse on the constitutional complaint reflects an urgent need to protect citizens whose constitutional rights are violated. According to the European Center for Constitutional and Human Rights, a constitutional complaints enable individuals to challenge acts of state authority that infringe upon their fundamental freedoms. The mechanism has long been established in nations such as Germany, Austria, Hungary, and South Korea, and is increasingly debated within Indonesia's legal scholarship as a potential path towards strengthening democratic accountability. Implementing constitutional complaint mechanism would also foster judicial activism, which is a proactive judicial attitude that prioritizes substantive justice over rigid formalism. As Eileen Cavagna argues, when constitutional rights are at stake, judges are driven to interpret the law progressively, ensuring that justice serves the people rather than remaining bound by textual rigidity. Yet, such activism must be balanced, for it carries inherent risks, such as judicial overreach, politicization, backlogs, and institutional overlap, may challenge the delicate equilibrium of power among state institutions. The study, therefore, addresses two issues. First, it explores the constitutional complaint as a legal instrument for the protection of human rights and the promotion of judicial activism. Second, it examines the potential imbalance of power that could arise from the judiciary expanded role through this mechanism. And then for the methodologically, the research employs a normative socio-legal approach combining the study of legal theory and principles with a broader socio-political context. It also focuses not only on existing law, but also on desired law to envision a more responsive and human constitutional system. For the first part, before elaborating on our findings, I would like to present two essential framework in our study, which is the theory of constitutional complaint and judicial activism, which are both interrelated. First, constitutional complaint are a distinct authority from constitutional review and arising in response to violations of constitutional rights resulting from the actions or negligence of state institutions rather than due to the unconstitutionality of norms. On the other hand, judicial activism refers to approach taken by judges and courts in controlling or influencing political and administrative institutions. In making these decisions, judges sometimes also create legal norms, although constitutional court judges do not explicitly demonstrate this paradigm because their perspective often change, adjustment to constitutional complaint require a paradigm of judicial activism, which needs to be considered in this study. Through this framework, our findings establish has at least 5 positive impacts on the constitutional complaint mechanism for protecting human rights in promoting the paradigm of judicial activism. First, it provides recognition and guarantees for individuals legal subjects. It means that citizens can complain directly with the constitutional court when their rights are violated. It is essential to address the findings of Palguna, a former constitutional judge, who stated that constitutional complaints have been filed since 2009. However, the Constitutional Court consistently declared admissible because it deemed constitutional complaint to be outside its jurisdiction. Second, through the constitutional complaint, it will be possible to review joint regulation issued by state institution which until now could not be reviewed by the Supreme Court or Constitutional Court because joint regulation are not currently part of material review authority of either jurisdiction. Third, judges can interpret articles related to rights in the Constitution progressively, reflecting the concept of a living Constitution. The dynamics of the issue's development will be addressed through the Constitutional Court's interpretation. For example, regarding the recognition of digital rights, environmental rights, and climate rights. Moreover, adjustment to human rights principles are not explicitly regulated, requiring no amendment to the Constitution. This space also directly claims rights that are not explicitly guaranteed and tests interpretation of ambiguous or discriminatory legal norms in the Constitution that remain general and abstract. Fourth, decision in the constitutional complaint can overturn administrative action, government policies, and ordinary court decisions that violate constitutional rights. There have been numerous instances of decision, policies, and government action that often do not favor the public, violate the constitutional rights of citizen and even cause harms. And last but not least, corrective measure of for the weakness of judicial review, which is limited to testing the constitutionality of norm, legal absence related to violations of rights resulting from the application of norm become the focus or subject of review by the constitutional complaint, which can be brought by any citizen in discriminatory court ruling and disappropriate action by public officials. For the next part, I would given the time for Ms. Trianoviantika.
Thank you, Ms. India. Can you move to the session discuss on the slide?
Okay. Wait.
Continue.
I think there is some issues. Let me, because it's different from, okay.
Okay, thank you. So, one issue that hasn't been sufficiently highlighted is the potential implication for power imbalances within the constitutional system. Attention, the point is crucial to mitigate various unanswerable possibilities arising from the expansion of the constitutional court authority, but become as a super body or independent of the executive branch. So here the essential point that will be discussed in this part. The next slide. Okay, the first discuss about the shift toward judicial overreach. Constitutional Court, the most powerful weapon for protecting human rights with expanding the jurisdiction. The expansion of gradually blur the line between law and politics, leading judges to make politically charged decisions with greater boldness and activism. The implication, the emergence of adjudicative overreach, and this has the potential to become even more intense with the authority of constitutional complaint. It is because the paradigm of judicial activism opened up a vast space for the Constitutional Court to expand its influence in the political realm further and weaken the principle of check and balances related to the separation of power. Naya and Misra state that judicial overreach occurs when Constitutional Court use judicial activism excessively, thereby exceeding the limits of their constitutional authority. In the South African Constitutional Court, claim found that symptoms of judicial overreach are growing stronger in line with the development of the principle of legality in the context of administrative law and the pragmatic approach used by the Constitutional Court in human rights litigation. Besides that, the expansion of authority in the form of constitutional complaint without clarity on its scope and limitation could lead to severe condition, conflict between state institutions, particularly between the judiciary, executive, and legislative branches, will have an impact on public welfare because the public that suffer the most when state function don't run smoothly. There are always limitations to the expertise possessed by the Constitutional Court in the field of law formation and implementation, which overlap with various social issues that are difficult to enumerate. The most extreme impact is the strengthening of judicocracy, which began with the expansion of the authority and involvement of the Constitutional Court in determining how legal policies are formed and implemented. And the second discuss about the backlog of cases at the Constitutional Court. The issue of the Constitutional Court workload with the addition of Constitutional Complaint Authority can become a very complex challenge when linked to other authorities it carries. The issue of case backlogs and workload must be understood not only in terms of quantity, but the quality of the decision produced. Concerning about the issue, the success rate of the Constitutional Complaint in Germany over the past decade has been 1.56%. Meanwhile, in Turkey, just 14%, where at least one right was found to have been violated. The other problem, the possibility of poor quality deliberation and decision that reflect procedural justice cannot be denied and may increase significantly. Serrano suggests a tendency among Constitutional Court judges to write dissenting opinion in decision, not merely due to the desire for anonymity, but also to reduce the workload associated with the large number of cases being handled. And the third discuss about the politicization of the Constitutional Court. Constitutional Court can be used as an actor to legitimize particular political interests, even if they are contrary to the principle of the Constitution. It has quite dangerous implications when the authority of the Constitutional Complaint is later manipulated for anti-constitutional end purpose to undermine public legitimacy or instrumentalize dominant political interests. A concrete example, the Constitutional Court decision number 90/2023, this known as court carving, where the Constitutional Court was used to legitimize the regime action and interest in a more subtle yet institutional manner by controlling the reasoning and interpretation of the majority of judges to manipulate the election process. We know that the Constitutional Court Ethics Council explicitly states that Judges Anwar Usman intentionally allow external interference in the decision-making process. So we can say that the decision 90 even the contain fatal errors, there are no legal remedies available to correct them. Reflect on case, the authority of the Constitutional Complaint may become a new strategy for political parties or certain political interest groups to strengthen their legitimacy. The Constitutional Court decision number 29/2023 support this argument when the House of Representatives support the decision of the minimum age requirement for presidential and vice presidential candidate, despite it being an open legal policy. It means that as long as the petition serves practical political interests, the Constitutional Court is often used an ally because changing provision through the court influence is easier than the formal legislative process. And the fourth discuss about the potential for overlapping authority between judicial institutions. There may be overlap or even conflict of authority, for example, with the authority to file lawsuits against factual action of the government and unlawful act by authorities in the state administrative court. It is because factual action may result in losses suffered by individual citizens, meanwhile unlawful acts by the authorities one of the object of factual action that can be brought before the state administrative court. The fundamental question regarding its adoption in Indonesia, such as whether the Constitutional Court will become the final forum for issues that parties have pursued in courts. And then the question is, do parties pursue the Constitutional Complaint as an extraordinary legal remedy outside of the Supreme Court? If so, then we are accelerating the transition to a judicocracy with the Constitutional Court as the main actor, given that its position will be superior to that of the Supreme Court in the future. It means that it is not impossible for the Constitutional Court to not only appear as a super body institution, but also shift from rule as a judic juris to a judic facti institution. With that precision, the adoption of accelerating will ultimately only reinforce the power imbalance in the existing judicial system in Indonesia. Based on that, we have to finding constitutional complaint limits to the next review agenda. It doesn't mean that a constitutional complaint has lost its urgency and relevance in Indonesia. So legal discourses must treat in prison with due seriousness to explain the necessary limitation on the constitutional complaints authority. The gaps in this limitation include apparent object of complaint that don't encroach on the authority of other instances, and secondly, strict and rational the limits to prevent backlogs and unreasonable workloads. And the third, standard for the admissibility of cases submitted, including the legal standing of the petitioner. And lastly, clear boundaries for the rules between the state institution. Meanwhile, political intervention from the executive and legislative branches is maintained and minimized. In sum, this study doesn't emphasize pessimism, but constitutional complaint is not a panacea that can cure all controversies arising from constitutional right violation. Constitutional complaint will only encourage judicial activism that guarantee the fulfillment of human rights as long as it is designed effectively and accompanied by restrictions that serve as a safeguard. At this point, where study focus on the limitation of constitutional complaint is needed to minimize negative impact. It has been a privilege, our tough, and we have the discussion contribute meaningfully to our collective understanding. We shortly thank the organizing committee of the ICCIS for to present and this esteemed conference, and we look forward to any question, feedback, or further discussion. Thank you for Prof. Diana.
Thank you for the third presentation. The paper argued that while constitutional complaint might give protection to human rights and allowing citizens to challenge unconstitutional act, but the presenter warns that without strict procedural limit and institutional safeguards, such expansion might risk judicial overreach, political misuse, and imbalance among state powers. Now I invite the first respondent for this paper, Dr. Sugeng from Universitas Bhayangkara, Jakarta. The time is yours. Only 5 minutes. Dr. Sugeng, yeah. Is there any Dr. Sugeng? Is there Dr. Sugeng? Dr. Sugeng from Universitas Bhayangkara. Yeah, the time is yours, Doc. To give response. I think you still unmuted. You're still muted. Yes, you might proceed. Okay.
Thank you for the opportunity to offer my response, Prof. Diana, to the article authored by Ms. Tria et al. I think this piece, which examines the constitutional complaint mechanism in the context of judicial activism and the protection of human rights, is highly relevant with the framework of contemporary democracy. In my opinion, this article offers an important contribution to enriching the discourse on Indonesia constitutional law, particularly concerning the urgency of adopting the constitutional complaint mechanism within the Constitutional Code. The authors successfully map out two central dimensions, like the aspect of protecting citizen constitutional rights and the potential for power imbalance in a balanced and well-argued manner. But nevertheless, there remain several conceptual and analytical areas for improvement to make this paper sharper and more constructive. The first, the philosophical dimension of law is underexplored, I think. This article raises an important idea about the constitutional complaint as an instrument for the protection of rights, but yet it doesn't sufficiently engage with the philosophical foundation underlying the idea. The second, the analysis of judicial activism needs differentiation. The authors highlights judicial activism as a progressive phenomenon that may lead to judicial overreach, but it doesn't yet distinguish between interpretive activism and institutional activism. The last, the Indonesian empirical context needs to be expanded. But overall, this article deserves appreciation for providing a valuable conceptual foundation for this course on reforming the constitutional court authority in Indonesia. However, to enhance its academic weights, deeper philosophical engagement and methodological systematization are required to show that the idea of a constitutional complaint function not only as a legal innovation, but also as a moral reflection and a form of state responsibility in guaranteeing citizens' constitutional rights. I think that's all for me. Thank you.
Thank you, Dr. Sugeng. Our next, I will collect all the response first and also the questions, and then going back to the presenter. Our second presenters would be, our second respondent would be Dr. Dewi Nurul Safitri from Constitutional Court of Justice. The time is yours.
Thank you for the chair, Professor Diana Puspitawati. Nice to meet you again, even though
Yeah, nice to meet you again.
Last time we met in Yogyakarta in
Yes.
2018 when I participated in ICCIS in Yogyakarta. Okay. Okay. Considering that I only have 5 minutes in this conference, so I will review directly the article of the speakers. First, after reading your article, I underline 4 things. First, your article writes that the Indonesia Constitutional Court considered a constitutional complaint through decision number 102 of 2009 regarding the review of law number 42 of 2008 on the permanent voter list. And now we know that right now the authority of constitutional complaint is out of the jurisdiction of the Indonesian Constitutional Court. And it means that formally we don't have this mechanism. So I suggest the author to modify the word constitutional complaint in this case, and therefore modify constitutional complaint with the word constitutional case in this paragraph. I think it's in paragraph, excuse me, in this article, paragraph 4 or 5, if I'm not mistaken. And then second, your article writes a positive point in my opinion by describing another residual problem from the adoption of constitutional complaints in Indonesia is the increased workload, which may be significant by describe the statistic cases handled by Indonesian Constitutional Court. To solve this problem, I think that your article can also discuss the procedure when the Constitutional Court handle constitutional complaint cases in the future, because the author is expert staff, the House of Representatives. So that's why I encourage the author to think also about the procedure when, well, one time in future the Constitutional Court has this authority, and then the author can also describe a procedure just a little bit more in this article. And then the third, your article writes an interesting point also on a potential power imbalance in the adoption of constitutional complaint. In this point, I think that it's important that your article also discuss how to solve the problem of potential power imbalance. For example, it's necessary, it's example from me, it's, it's necessary to make a dialogue between constitutional court judges and Supreme Court judges in Indonesia. I give you an example, like in France, judges in Cassation Court, and then State Council and also Constitutional Council, they practice the dialogue between them. It's not an intervention, but it builds mutual comprehension between three jurisdictions. It's a juridic concept designing informal interaction between different jurisdictions. Therefore, judicial activism is not only about legal opinion and interpretation by judges, as you described in your article, but also you can describe also dialogue between judges. It's challenging for your article. This dialogue is necessary because there's an intersection between decision of Constitutional Court and the Supreme Court. And the fourth, it's a small thing, but I think it's important and urgent. In your article, page 3, you write that the implementation of constitutional complaints has been widely adopted in several European countries, including Germany, Australia, and France. And then you cite this phrase from the article written by my colleague, Lutfi Chakim. In my experience after studying in France, uh, I never heard that France that constitutional complaint mechanism. And then my supervisor, he's a professor at Hunting Sorbonne University, Sorbonne Law School. He said that that's a constitutional complaint mechanism in France. It's unlikely in Germany. In France, there's a mechanism close to a constitutional complaint, but not constitutional complaint itself. It's a system of QPC, question priorité de constitutionnalité. In English, we call it priority question of constitutionality, and we call it QPC. And then it means that plan in French language we call it the plan avec constitution de partie civile, which means complaint with civil action in English language. It's a mechanism whether a victim can lodge a case to an investigating judges to examine whether there's a criminal infraction or not. That's constitutional with action with a constitution. But in QPC, just like judicial review in the constitutional court, every justice seekers, even though they are foreign citizens, they can lodge a constitutional case to constitutional council, whether a law, an act after their promulgation is contrary of the constitution. So I suggest you to erase the word France, especially in Article 3, because I believe that you have cited a good article written by Lutfi Chakim, but imagine if your article is read by French people, by French professor, because Constitutional Review publish your article internationally. So it's very important to raise it. And finally, I appreciate all of the speakers to write this article, and having analyzing deeply developing constitutional complaint mechanism in Indonesia. Bravo for your work, and your work has been selected by Constitutional Review. And thank you very much for the chair, Professor Diana Wati. And the floor is yours.
Thank you. And I invite other participants to raise questions. Okay, if there's no questions, so I'm going back to the presenter that we have several questions that Dr. Sugeng stated. Constitutional complaint should be seen as moral reflection and to guarantee social civilian rights and not distinguishing between I think I missed this part, judicial activism and constitutional complaint. And Dr. Dewi, there are 4 questions that suggest the author to modify constitutional complaint in paragraph 4 on 5 and how encourage the House of Representatives to discuss how if the jurisdiction to have held the constitutional complaint is given to constitutional court and how constitutional court will handle the complaint in the future, and then how it is important also to discuss how to solve the potential power imbalance. And the last suggestion from Dr. Dewi is to recheck whether the France has practiced constitutional complaint because it's not, it's rather similar to constitutional complaint, but actually it's not constitutional complaint. Okay, the time is yours to respond to the comment previously.
Excuse me, Professor Diana. I revised for modify page 7, which written decision number 102.
Okay.
Changing
Yeah.
constitutional complaint with constitutional cases.
Yeah.
Thank you.
Okay. Okay. Please respond.
Okay.
Maybe Ms. Tria first, or?
Okay, I'll go and then you can.
Okay.
Thank you, Prof. Diana, and thank you so much for all your thoughtful response, question, and the constructive feedback from the Dr. Sugeng and Ms. Dewi. We truly appreciate and consider all the feedback, suggestion, and all of your perspective from Dr. Sugeng and Ms. Dewi in our paper. We truly consider that the constitutional complaint mechanism serves as a catalyst for judicial activism that advance the protection of human rights, yet it simultaneously poses the risk of disrupting the balance of power among constitutional institutions. Basically, in our research is limited and focuses on looking at two perspectives that could occur when constitutional complaints are applied and the authority is attached to the constitutional courts. But once again, we don't view this idea is eliminating the essence or the urgency of the application of constitutional complaints in Indonesia. And then last, thank you so much for all your notes and feedback. For our research, we will correct and add some notes that have been given for our paper. And I'll now give the floor to my colleague, Ms. Andia, if there's anything they'd like to share. Thank you.
Okay, thank you. Personally, also for me, I really appreciate the feedback and some revision from Dr. Sugeng and Dr. Dewi. I believe that our paper our paper needs have a lot of room of improvement. So I really appreciate it, and we will try to our best to revise our paper into so it can be it can be better quality, and also for the also have part or give a contribution to academics. Maybe that's for me also. Thank you. Yeah, back to the chair.
Okay. Okay, thank you. I think, hang on a sec. Hang on a sec. I think we came to the end of this fourth session. So let me just sum up a bit that the first presenter support the idea of improving the right protection through interpretative expansion of constitutional court, but warns that such step should be supported by by formal amendment and legislation. And the second paper proposed a more pragmatic reform that transforming the existing governmental unlawful mechanism act into a constitutional thought framework that is emphasizing the procedural reform and alignment with constitutional principle. And the third paper, while supporting constitutional complaint system to enhance the judicial activism, but caution also on the procedural safeguard that this mechanism could destabilize the separation of power. So collectively, the three paper highlights the tension between ending judicial protection and preserving institutional balance, underscoring the need for carefully designed reform that enhance constitutional accountability without undermining democratic legitimacy. Thus, my concluding reflection is that constitutional democratic restraint is not a weakness, it is a wisdom. Judicial activism, untempered by constitutional fidelity, is transforming justice into governance. So to sustain Indonesian constitutional democracy, reform must therefore be both legally legitimate and institutionally prudent to ensure that the court remains what it was designed to be, the concise of the Constitution, not its substitute. I think that's all for this session. I give it back to the Master of Ceremony. Thank you and have give applause to all of the speakers. Yeah.
Thank you, Prof. Diana, as our chair for session 4 on 7th ICCS Day 2nd. And now I would like to invite Professor Heribertus Jaka Priyatna from University of Gadjah Mada as our chair for session 5. Professor Jaka, the time is yours.
Thank you very much for this time being, ladies and gentlemen. It is my great pleasure to welcome you again in this 5th sessions, and we will have 3 speakers outlining a very important aspect of the individual complaints or strengthening the protections of constitutional rights through constitutional complaints that will be delivered by 3 speakers. First, from Dr. Sugeng. Thank you very much, Pak Sugeng. And also the second ones will be presented by Dr. Ervina Faudatul Khelimi and also Ms. Fitria Maulidia. And it is reflected in amicus curiae and constitutional complaint, instrument for public participations in the protections of the constitutional rights. And the third speakers will be delivered by Mr. Hikam Hulwalullah and also Mr. Torik Abdul Aziz Wibowo, that will entitle the hybrid multi-level constitutional complaint, reforming constitutional right protections in Indonesia. So this topic will be viewed from the context of the individual's rights through the constitutional complaints. And I will also invite respondents to give feedbacks for the presentations delivered by the speakers. First, without further delay, may I invite Pak Sugeng from Bayangkara University of Indonesia to deliver the first presentations. Pak Sugeng, please check your audio whether we will hear you to have the sessions. Pak Sugeng, please.
Okay, thank you, Prof. Heribertus Jaka. Could I share my screen? Okay. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh. Good afternoon, everyone. Honorable Professor Jaka, distinguished speaker, respondent, and all participants. Today I will present my paper entitled Civil Society as Rule as a Constitutional Actor, exploring its involvement in constitutional complaint procedures in modern legal orders. My presentation today investigates how civil society can function as a constitutional actor in its own right, particularly through procedures of constitutional complaint. It asks to what extent do modern legal system permit civil society not only to raise grievance but to assert rights, contribute to the interpretation of constitutional norm, and influence change. And crucially, how do these processes balance inclusivity, accountability, and the rule of laws? I hope that through this analysis, we can gain insight into the transformative potential of civil society participation and face candidly the legal, institutional, and normative hurdles it must overcome. A vibrant and independent civil society is often regarded as a crucial condition for a healthy democracy, as it functions both as a social buffer and as an ethical counterbalance to state authority. Civil society plays the role of watchdog, public educator, and social mobilizer, even when formal institutions weaken, thus embodying the practical expression of the rule of law from below. The transformation of civil society role within the modern rule of law cannot be separated from the dynamic of democratization, globalization, and digitalization. At the global level, civil society also plays a significant role in addressing transnational challenges such as climate change, cybercrime, and the oversight of multinational corporations. In the digital era, the transformation of society role is evident in its capacity to organize technology-based advocacy movements through social media and digital platform. Civil society can broaden the reach of legal advocacy, monitor abuses of power, and educate the public about constitutional rights. This phenomenon shows how civil society has shifted from a local actor to a network global agent in the pursuit of legal justice. Within the modern rule of law, civil society's role has evolved from a purely domestic watchdog into a multi-level actor operating at national, regional, and global arenas. Presence of constitutional complaint mechanism in various countries demonstrates the availability of direct participatory channel for citizen and civil society organization to challenge constitutional violation and discriminatory state practices. Conceptually, civil society is understood as a social sphere distinct from the state, the market, and the family, comprising both collective and individual action aimed at advancing common interests. Habermas emphasized the importance of civil society in sustaining the deliberative public sphere, where national discourse and communication free from domination serve as the foundation for democratic legitimacy. From a typological perspective, civil society encompasses various forms of organization and movement. Traditionally, this typology has included NGOs, labor unions, faith-based organizations, local communities, and professional associations. However, in the contemporary global context, civil society also extends to digital movement, transnational network, and identity-based communities. Constitutional complaint is a legal instrument that enables citizens to file a direct petition with the Constitutional Court or an equivalent body when their constitutional rights are violated by state action, whether through legislation or administrative measure. This model has been adopted by various countries, such as South Korea, Spain, and Hungary, as a mechanism that broadens the potent protection of human rights within modern constitutional law system. In the evolution of modern law, several procedural instruments have developed to strengthen access to justice and expand public participation in judicial process. Three of the most prominent are amicus curiae, class action, and strategic litigation. Non-government organizations serve as intermediaries between society. In my article, I compare the role of civil society in three countries, such as Germany, South Korea, and Indonesia. I explore how each legal order structure constitutional complaint procedure, how civil society actors participate or excluded, and how practical and normative constraints shape their involvement. By examining these three systems side by side, I aim to highlight best practices, common obstacles, and pathways of reform that must strengthen civil society's constitutional role globally, and particularly in Indonesia. In Indonesia can strengthen legal mechanisms that allow individual and civil society organizations to seek protection of their constitutional rights directly in court, not merely as observers. Organized and professional civil society will bolster social oversight of power and provide public legitimacy for major constitutional decisions. Indonesia can proactively compare and adopt international principles in contract law, human rights, corporate governance as part of constitutional interpretation and constitutional complaint procedure. Procedural obstacles are one of the fundamental challenges of optimizing civil society participation in constitutional complaint mechanism. In many jurisdictions, standing requirements are so strict that access is limited to individuals who are directly harmed, while civil society organizations or public interest groups are often excluded. This creates a paradox since constitutional issues frequently have collective impact that extend beyond purely individual interests. Beyond standing, another barrier is limited access to the constitutional court, geographic factor, technological constraint, and procedural complexity often hinder vulnerable groups or communities in remote areas. Litigation costs are also a significant factor, although some countries provide free waivers or legal aid. In practice, court fees, advocacy expenses, and time required often foreclose opportunities for full civil society participation. Strengthening the position of civil society as a constitutional actor requires a complementary normative, institutional, and cultural measure. Explicit legal recognition of civil society's role in constitution mechanism is needed. Without formal acknowledgement in the constitutional text or basic law, civil society's involvement risks remaining sporadic or dependent on ruling powers' political interpretation. From an institutional perspective, civil society needs institutionalized channel of participation. Mechanisms such as amicus curiae, public hearing, or constitutional forum can be formalized to ensure that civil society's voice is integrated into both judicial and legislative decision making. The recommendation also emphasizes building civil society's own capacity. Participation will have little meaning without support for legal literacy, technical competence, and sustainable resources. In conclusion, this study shows that civil society involvement in constitutional complaint procedure is merely a technical add-on, but an vital strategy to ensure that the protection of citizen rights goes hand in hand with judicial discipline. Civil society should not be confined to the role of an external watchdog. It must be recognized as a constitutional actor actively engaged in maintaining the balance between state power and individual rights. In practical terms, strengthening locus standi for civil society organizations should be prioritized so that their access to filing constitutional complaint is not hindered by overly stringent procedural limits. At the theoretical level, this study underscores the need to reinforce the idea of participatory constitutionalism, which positions civil society not merely is an external watchdog, but as a co-guardian of the constitution alongside institutions. Thank you for your attention. I look forward to your question and comment. Let's help deepen our shared understanding and strengthen our pursuit of justice, accountability, and constitutional protection. That's all. Thank you very much.
Thank you very much, Mr. Sugeng, for your wonderful and fruitful presentations and in timely manner. So I outlined several key points delivered by Mr. Sugeng. First, that the constitutional complaint is a modern mechanism to be upheld for safeguarding individuals' rights in the modern democratic states in Indonesia. It is a key point that he already outlined. And the second one, even though it is very necessary to be established, there is an institutional and political resistance for such establishments. Also, the second one is the absence of the explicit legal provisions in our constitutions. And the next challenge that we can raise in this session would be whether individuals, citizens in Indonesia really know about this constitutional complaint mechanism first, and whether this kind of mechanisms could be as a risk mitigation mechanisms for them to lodge complaints in our constitutional courts. It is only for several hints that may raised by respondent to strengthen the paper delivered by Ms. May I invite Ms. Tria Noviantika and also Ms. Andia Musafira and also Mr. Rilo Pambudi as the first respondent to Mr. Sugeng presentations. May I invite Ms. Tria, Ms. Andia, and Mr. Rilo?
Yes, Prof.
Please, Pak Rilo, floor is yours.
Thank you, Prof. Cheto. It is a pleasure to see you again. And dear speakers, committees, invited participants, and distinguished justice, good morning to all. On this occasion, I'm honored to respond and express my appreciation for Dr. Sugeng's excellent article, which raises an interesting issue by highlighting the role of civil society in modern legal system. And this article makes a significant contribution to expanding the discussion on civil society as a constitutional actor. And Dr. Sugeng also presents a thoughtful, normative, and comparative approach that examines practices in Germany, South Korea, and their relevant to Indonesia. In addition, Dr. Sugeng raised the concept of the rule of law from below as an ethical framework that strengthens the legitimacy of constitutional complaint, and ultimately positioning civil society as a constitutional actor within the constitutional complaint process will reflect the evolving in understanding of constitutional democracy in Indonesia, one that not only protects rights to the judiciary but also promotes participatory constitutionalism as a shared responsibility between the and its citizens. However, for discussion, there are several points that, in my opinion, need to be considered to strengthen the analysis and discourse on this issue. First, perhaps who expects empirical analysis or case studies that so how civil society actually plays a role in the constitutional complaint mechanism in the countries compared. In that way, the article would not only offer ideal discourse but also practical application. And the second is this article. Civil society is often assumed to be progressive and pro-democracy oriented. In fact, however, there is a phenomenon of illiberal civil society that actually support anti-democratic agendas. And the Indonesian Constitutional Court has recently been confronted with this issue. Actually, this phenomenon was mentioned in paragraph 6 of introduction in this article, but it was not elaborated upon further in the discussion. In my opinion, it will be more comprehensive if this were also reviewed and how the discourse of it can respond to this phenomenon. And this section is also relevant for portraying the dynamic of political power involving the judiciary, lawmakers, and civil society, of course, because resistant to the institutionalization of constitutional complaint and the strengthening of civil society often comes from political actor. And finally, I would like to conclude this response with two questions related to the article. First, how can we ensure that civil society involvement in the constitutional complaint mechanism doesn't turn into a form of judicial populism that threatens judicial independence? And the last question is, what institutional or procedural guarantees are needed to ensure that civil society participation in the constitutional complaint process remain constructive, representative, and devoid of political manipulation? I think that is my response, and thank you for the opportunity. Best wishes to Dr. Sugeng for your research, and I give it back to Prof. Cheto. Good morning to all.
Thank you very much, Pak Rilo. And once those who call me Pak Cheto, it means they have a very personal touch with me. And thank you very much, Pak Rilo. Sehat selalu, sukses selalu. And there are two concerns delivered by Pak Rilo for your suggestions of Pak Sugeng articles. First, about the actual best practices from other countries for the individual complaints, and second, about the institutionalizations of the individual complaints as a constitutional rights to be elaborate more. And there are also two questions to be redefined to make the paper is as best as good, Pak Sugeng. And may I invite the second respondents, Ms. Intan Permata Putri from Indonesian Constitutional Court. Bu Intan?
Hadir.
Thank you very much, Bu Intan.
Thank you,
Please,
Mr.
floor is yours.
Moderator. Oh, yeah. Thank you so much, Bapak Moderator, Bapak Jaka, and also speakers and also other respondent. And then thank you for committee and for having me as a respondent. That was an in-depth and complete explanation from Mr. Sugeng paper that I think I found some cases that interest me well, and then I think it's similar with Mr. Sugeng concept of subject of a constitutional complaint. That means civil society, and then straight to the point. Let me see what cases that I've found before, and then it's all come from the apa namanya constitutional court from German. It's only from German. I can't find from the South Korea, but I think maybe it will enrich our topic this session. The first cases is come from applicant from PETA or people for the ethical treatment of animal versus piglet. I think it's interesting because the issue is seeking for protection of our animal rights from abusing method, and this case also illustrates the broader trend of society as a subject as constitutional complaint, and also animal as subject to receive or granted several rights, not only human, I think. And then the second case is come from applicant non NGO from reporter and journalist, and then they filed a constitutional complaint cases against BND law. The issue is the telecommunication privacy and press freedom. I think that's interesting cases. It's just because at first that cases that law is enacted for only spy and surveillance activity for foreign country, but for spy from German, and then it has a broader impact for also for citizen Germany in the foreign country. That case is a very uh, uh, intriguing. Some countries is like United States, and also become a point of view in several times. uh, and then that cases is also yeah, maybe it is similar also because the subject is come from civil society, not come from the German citizenship, but the last cases is very unique. It's just because the applicant is come from German citizenship, but they support with the environmental organization. It's kind of, oh yeah, the applicant is come from young and adult from Germany citizenship, and then supported by a German, and then also Greenpeace Germany and German Watch and Protect the Planet. That's only support, not become a subject in the constitutional complaint cases. And then the issue in this decision is very unique. It's just because the German Constitutional Court mentioned that it was the right to mention that right to good environment, adequate environment, it's also for the present and future generation. It's just we need to have action for the delay climate extreme, and then that kind the some harm effect that cause future generation lose their right to the good environmental. That kind of action is just like reduce the emission, and also have a certain categories of vehicles, I think. But that's interesting because also acknowledge the future rights of our generation, not only present. But the unique is this is come from German citizenship who supported from environmental organization. I mean, let's jump into the real question. Maybe first question is that these cases are trying to claim over certain rights and expand the subject or applicant to offer constitutional complaint cases, maybe not only subject tapi but also support as a supporter in some cases it's just like the third one or the last cases. And then my real question is, does the German Constitutional Court really have a concern to acknowledge that civil society is a subject? Because I think it's only one cases that belong to the first cases that maybe German acknowledge as a civil society as a subject. I think it's a part of the party of constitutional complaint cases, I think. And then
Thank you, Ibu Intan.
yeah.
Because time is already lapsed, much appreciated for your concerns. And I think Pak Sugeng from Bu Intan, there is a huge challenge, not huge challenge, a suggestion for you to add about the practices from the German legal system for the constitutional complaint. Yeah, and I already underlined these important issues as raised also by Pak Rilo Pambudi. And may you respond to his and her questions with regard whether the judicial complaint, constitutional complaint may reach to judicial populisms. I think it is the first response to Pak Rilo. Floor is yours, Pak Sugeng.
Thank you, Prof. Zaka. Maybe I would like to brief response. Thank you for the excellent point and important question from Mr. Rilo and Bintang. For Mr. Rilo, in my opinion, constitutional complaint can form part of a multi-form. Complaint can form part of a multi-track strategy, using them alongside administrative litigation, ordinary courts, human rights commission, or international mechanism, depending on that. A successful constitutional challenge may carry strong normative and symbolic. That litigation alone is rarely enough. CSOs, civil society organizations, often need to complement work with public campaign, media advocacy, policy engagement, and community education to maximize impact. And amicus curiae, interveners and broader stakeholder input can deepen legal argument, introduce social context, and influence outcome. And we to this Intan. I think there is many obstacles CSO face in Indonesia when comparing with Germany and South Korea, such as legal standing rules. Civil society must show actual or particularly harm. This is sometimes difficult when the issue is more general or public. Yes. The limited scope of what may be challenged, not always politicized, administrative act and executive propaganda. High cost burden of litigation, need for evidence, research expert, not all CSOs, have sufficient resources. Lack of awareness or expertise on procedure rules, legal drafting or judicial strategy, and the last, potential bureaucratic or administrative hurdles in gathering material, filling and interacting with courts. Maybe I can give a complete answer, but I can confirm CSOs able to fill gaps the formal democracy institution may not address.
Right.
That's first of all.
Right. Thank you, Pak Sugeng. Your response is quite clear in the sense that it is also fruitful to make some review from the German practices for your paper. Yeah. And ladies and gentlemen, the first session from the fifth session will be ended because of the lapse of time. And thank you very much, Pak Sugeng, Pak Rilo Pambudi, and also Bu Intan for your insightful comments for Pak Sugeng presentations. Thank you very much for your times and your presentations. And now we are entering into the second speakers for this fifth sessions. May I invite Dr. Ervina Fuadatul Kilmi and also Bu Fitri Mauludia from Kiai Haji Ahmad State Islamic University for the second presenters entitled Amicus Curiae and the Constitutional Complaint, Instrument for Public Participations in the Protections of Constitutional Rights. You have 15 minutes for us, and may I also invite Mr. Reza Saputra for the first respondent, and the second one is Ibu Sarvina Sabila from Indonesian Constitutional Court. Ibu Ervina, floor is yours.
Bisa saya share screen? No. Share screen.
Yes, we already have your screen, Bu Ervina. Floor is yours.
Okay. Yeah. Maybe my friend is share screen. Fitri Maudia.
Administrator arranged that Ms. Fitri Maudia to be co-host to present her PPT. Please.
PPT, yeah.
Please give Bu Fitri access.
No, it's not give access.
Right, while the administrator try to give you access, you may, the presentation is in the screen. Please, Bu.
Ini saya bisa ini enggak.
It is echoed, Bu Ervina. Bu Fitri, you may thank
you. Thank you, Prof. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam.
Good morning, Honorable Professor Dr. Herbertus Jaka Triana, and then the Honorable participant and ladies and gentlemen. Okay, today we presented about amicus curiae and constitutional complaint instrument for public participation in the protection of constitutional rights. The background is the limitation of citizens in demanding constitutional rights protection have become a polemic. The first, there is no legal instrument that specifically regulates the procedure for citizens to file a constitutional claim. The second, public access to constitutional justice is often hampered by political intervention that is not friendly to the interests of citizens. For example, the participation of amicus curiae, which has no binding effect on the decision of the constitutional courts, leads to the potential politicization of judicial institutions and inconsistent legal provision. Well, the constitutional complaint system is not yet explicitly enshrined in the Indonesian legal system, which is to uphold constitutional rights. The next, the problem formulation. What is the position on urgency of amicus curiae in the protection of constitutional rights through constitutional complaints? The position of constitutional rights in Indonesia occupy a fundamental position granted by the 1945 Constitution and the human rights law as the main normative benchmark that obliges the state to guarantee and protect the basic rights of citizens. And then constitutional complaints serve as last resort or ultimatum remedium that allows individuals to directly challenge action or decision of courts or the constitutional court that violate human rights. They are complemented by the formalization of the role of amicus curiae to present an independent legal perspective. thereby strengthening the integrity of the judiciary and preventing political bias. The next. Uh, okay, about how the concept and role of amicus curiae in the legal system. Amicus curiae is an instrument of public participation that provides independent legal opinions as a form of social control over decisions related to citizen constitutional rights. However, in Indonesia, its position is weak because it's only considered as additional information without binding force. Unlike the practice in the United States, which is formally regulated. Therefore, the role of amicus curiae needs to be reformulated so that it can broaden the legal reasoning of judges, strengthen the legitimacy of constitutional court decision, and become an integral part of the constitutional complaint mechanism is not yet available. Okay. uh, amicus curiae is began to begins from the Constitutional Court of Indonesia decision number 19 2023. Uh, the Constitutional Court decision number 90 2023, which amended the age requirement for presidential and presidential candidates, serves a concrete example of how political intervention and conflict of interest can threaten citizen constitutional rights. The ruling that allows candidates under the age of 40 to run for office provided they have previously served as regularly had is considered a violation of the principle of equality and legal standing, and its ripple indication of political partiality. Furthermore, the ethical misconduct of the justice involved in this case have further undermined the credibility and independence of the Constitutional Court. Therefore, this underscores the urgency of implementing on conditional complaint mechanisms strengthened by the role of amicus curiae to prevent the politicization of the judiciary and ensure the protection of citizen constitutional rights. How about amicus curiae in the decision of the Constitutional Court number 1 2024? In Constitutional Court decision number 1 2024 regarding the dispute over the 2024 president election result, the role of amicus curiae was only considered as an additional perspective of implementum without binding force, because the judge's conviction was much more of formal evidence from the petitioner, respondent, related parties, and expert testimony. Although the documents submitted by academic and civil society organizations were appreciated as a contribution to the strengthening democracy and transparency in the judicial process level. Legally, the assistance was not recognized as relevant practice as stipulated in Constitutional Court Regulation number 4 of 2024. Thus, amicus curiae function was more as a preventive and consolidative public participation mechanism to maintain the accountability of judges, but has no direct influence on the substance of the decision. How about comparison of amicus curiae practice in United States? United States, a comparison of amicus curiae practice in Indonesia and the United States reveal fundamental difference. In Indonesia, amicus curiae opinions are considered merely additional moral or academic information. When enforced, a judge focus more on formal evidence. In the United States, however, amicus curiae is formally regulated through Rule 37 of the Supreme Court rules, allowing amicus brief to be directly set in decision and exerting a strong influence of the formation of legal opinions. This gap underscores the need the need to formalize the role of amicus curiae in the Indonesian legal system so that it can make a substantial contribution to protecting the constitutional rights of citizens. The position on urgency of amicus curiae in the context of constitutional complaints. The position of amicus curiae is very important in constitutional complaint because it functions as an instrument of public participation that strengthens the protection of constitutional rights, provides an objective legal perspective, and is oriented towards broader constitutional rights in producing fair, transparent, and substantive just decisions. Where in Indonesia, the role of amicus curiae is still limited. In the United States, amicus brief as external parties effectively determine the content of decision directly by providing information or brief reports to assist judges in specific cases regarding the number of parties potentially affected, the position or status of the parties to the case, and offering scientific, political, and legal opinion as alternative information when judges are not particularly satisfied with the opinion of the parties to the case. Conclusion. Amicus curiae has a strategic position as a mechanism for public participation that strengthens the protection of citizens' constitutional rights through constitutional complaint by providing additional information or legal brief as instrument of social control that provide objective, multidisciplinary, and substantive justice-oriented input to just legal consideration during the decision-making process to strengthen the implementation of the constitutional complaint system in the future. However, to date, public participation to amicus curiae has not been specifically regulated in the Constitutional Court, thus requiring the strengthening of the normative framework by integrating amicus curiae and constitutional complaints as a single entity in the protection of citizen constitutional rights. This is a recommendation. The constitutional courts needs to clarify the role of amicus curiae through measurable rules and mechanisms, while lawmakers are expected to formally regulate constitutional complaint as a means of protecting the constitutional rights of citizens. The integration of amicus curiae into this mechanism, supported by a transparent digital platform, will strengthen public participation, maintain the independence of judges, and ensure that the constitutional court decisions are oriented towards protecting the constitutional rights of the people. I think it's enough. Thank you very much for your kind attention, and I look forward to further discussion during this conference. Thank you. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you very much, Ms. Ervina, for your insightful presentations. In your presentations, I highlight that the amicus curiae mechanisms has legitimate motivations to strengthen public participations for the claiming of constitutional rights. So, ladies and gentlemen, may I invite two respondents, Mr. Reza Saputra and also Ms. Sarvina Salbila, to present your response to Bu Ervina Hilmi presentations for maximum 10 minutes, each of 5 minutes, and then I will continue to invite participants to have a question and answer, which I missed in the first sessions. Mr. Reza? Pak Reza? Or may I invite Ibu Sarvina Salbila from Indonesian Constitutional Court to deliver your response, please?
Okay, me first?
Yeah, please, Bu Sarvina. Thank you.
Okay, thank you, Prof. Yaka. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam.
Good afternoon to esteemed college, respected speakers, and all the participants of the 7 ICCIS. First of all, I would like to congratulate to Ms. Ervina and Ms. Fitri as the speakers. Your paper gives insight to the intersection between amicus curiae and constitutional complaints in the context of protecting constitutional rights in Indonesia, and it highlights the importance to reformulate amicus curiae as not merely as a supportive tool, but as an integral part or component within the constitutional complaint framework, and as you argue, to strengthen public participation and serves as a means of social control. Well, this paper provides a well-structured, thoughtful analysis through the following key points, like the position of constitutional rights and their protection mechanism in Indonesia. And you state that the concept and role of amicus curiae in the legal system, and you make some linkage with the Constitutional Court's decision number 90/2023 and number 1/2024. And the last one, you make the position and urgency of amicus curiae in the context of constitutional complaints and comparison with the United States. And based on these settings, I would like to ask some questions. The first one is, why are you decide to make the linkage between the amicus curiae and constitutional complaint? Do you see a disadvantage when this instrument operates separately as opposed to the synergy created when they are integrated? Like, what is your choice of the mentioned Constitutional Court's decision to illustrate this linkage? The second one is, do you think that amicus curiae hold a greater relevance when aligned with the Constitutional Court rather than the judicial review or deciding disputes over the results of election result? Because I take notes on your paper on like page 6 that the court tends to treat amicus curiae merely as moral and academic considerations rather than as binding legal instrument. And the last one is, what contextual or institutional similarities do you find most relevant to the Indonesian setting for the reason choosing the US model of amicus brief? And finally, I was particularly intrigued by a statement that I quote, the absence of a constitutional complaint mechanism in Indonesia makes citizens vulnerable to politically oriented constitutional interpretation. Well, for me, it underscores how the establishment of a constitutional complaint would provide citizens with the necessary space to file complaints directly when their constitutional rights are infringed. And I believe these reflect an urgent need for systematic reform that prioritizes constitutional accountability and public trust. And I think that's all for my response. Thank you once again for your presentation and contribution. Assalamualaikum warahmatullahi wabarakatuh.
Much appreciated, Ibu Sarvina, for your insightful comments. Before I deliver to Ms. Ervina, may I invite from the distinguished participants to make a questions to respond to Ibu Ervina's presentations, please.
Okay.
Are there any questions from the participants?
Okay, thank you. I want to answer.
Hold, Bu Ervina, hold, please. I offer the opportunity for the participants to add questions for the perspective of the participants, if there are any. Participants, please. Yeah, Pak Agus BKPS. Pak Agus BK, please. Floor is yours.
Hello, am I audible?
Yeah, loud and clear, Bu Jane, please.
Okay, thank you for the time. So, thank you for Dr. Ervina for your presentation. It's such a remarkably thorough and insightful discussion on the intersection of judicial independence, political influence, and moral responsibility within Indonesia's constitutional justice system. The way you emphasize the role of moral awareness and judicial ethos in upholding independence from political interference and demonstrate a deep understanding of both the legal principles and their ethical implications Moreover, your exploration of how political appointments can compromise judicial objectivity adds a realistic dimension to the debate on the separation of powers and judicial credibility. I also find your discussion on the urgency of establishing a constitutional complaint mechanism and recognizing amicus curiae participation to be highly relevant and forward-thinking by suggesting this mechanism as potential solutions to restore public trust and safeguard citizens and citizen constitutional rights. Your paper, I acknowledge that move beyond critique toward constructive legal reform. This demonstrates not only an analytical but also a genuine concern for strengthening Christian institutes in Indonesia. So I raising two questions. So the first one, considering Indonesia's current constitutional structure, what potential legal or institutional challenges might arise in implementing a constitutional complaint mechanism? And the second questions, how might the involvement of amicus curiae practically ensure judicial impartially in politically sensitive cases, and what safeguards should accompany this mechanism to prevent its misuse? Thank you so much.
Right. Thank you very much, Ms. Jean Natasha, for your challenging questions. Bu Ervina, there are four questions with regard to your presentations. May you please give a response to Ms. Sarvina and also to Ms. Jean Natasha? Please. Ibu Ervina, please.
Okay. Yeah. Okay, I want to answer the respondent about from Miss Sabrina Sabila. Okay,
Bu Ervina, Bu Fitri's laptop, could you please mute because it is echoed?
Okay, about the urgency of amicus curiae is about especially is the political interference in the constitutional court here. So needs a check and balance from society, civil society, especially there is amicus curiae. So is the way effective because the thing of amicus curiae is not is come from academic and then it's academic and then a civil organization. This is urgency is the most I think is the political interference. So that amicus curiae is needs to the need to make in the legal system, especially in constitutional complaint, because constitutional complaint is instrument is the last instrument for the protecting individual rights. I think is enough for me. So um, from Miss Safina Sabila, okay, it is.
Right. Thank you, Ervina. One questions how to balance, about internal difference mechanisms with the external mechanisms to be worried from the participants for the establishment of the amicus curiae mechanisms in the Indonesian legal system. How will you respond to these concerns, Bu Ervina?
Okay. How to balance to maintain? I think the balance is okay. Is the problem is not regular to amicus curiae. So I I I have said I don't have a thing about but I have mentioned to balance the uh, procedure procedure in the constitutional court about the process is exists, but uh, judge judge is not only the evidence, they're not only evidence, but is the he makes the other perspective because because amicus curiae is external. They have uh, has have is of point of view has uh, pandangan yang luas ya. So is help a judge just to make decisions. I think I think is I think it I think it's like that.
Right. Thank you, Bu Ervina. For the last chance, may I invite Ibu Angela from BKN? You already raised your hand, please, Bu Angela.
Opportunity, Pak Jaka. I feel very honored. Bu Ervina, may I raise a question for you, which might sound very simple and but the answer might not be as simple as the question itself. We have listened to the explanation from you and also the response from the two respondents. But I think there is an important question that need to be raised after all the good impact that might come from active amicus curiae from the society for the court decision and ruling. But realistically speaking, may I know your perspective on the real impact? Is amicus curiae or has amicus curiae ever affected court, especially the constitutional court decision or ruling, or is it just, how to say it, a formality that I could say a lot of university students and other organizations give their amicus curiae to the courts?
Bu Angela, may I interrupt whether your question is whether amicus curiae give a good impact for the community participations or not? Is it your question?
No, not exactly that. My question is it really does amicus curiae in Indonesia, based on the recent events, really have a good impact or really affect the constitutional ruling?
Right. So, Bu Ervina, could you please respond to these questions, please?
Thank you very much, Pak.
Yeah, thank you, Bu Angela, for your times and your questions. Bu Ervina.
Okay. Thank you very much. How about check and balance? Yeah, amicus curiae. Amicus curiae is amicus curiae is no adalah is not okay, is give information or legal brief about opinion and argument. Yeah, argument about social, politics, and law. So, is the give knowledge from judge. Yeah, and give there is this indicate about law is higher or not, and then This give information or document legal brief is to give useful for society, and then uh, and and then amicus curiae is give to understand textual about textual. So in this knowledge for judge to give interpretation more than more, yeah. So is capacity.
Bu Ervina, because time is lapsed, could you please wrap up your answer, please?
Okay. Yeah. I think this is amicus curiae provide writing information or documents in the form of public opinions and scientific, social, political, and legal arguments to explain the intent of legal norms in the Constitution that are still abstract, whether they contain legal force, whether they are fair, whether they provide legal certainty, whether they are beneficial. This information or document are forwarded to the judge's interpretation to understand the meaning of the text. This
All
provides
right,
the
Bu Ervina, may I conclude that Bu Angela, that amicus curiae, based on Ervina's argument, it really has indirect influence for a better advocacy to the community, if I'm not mistaken. Yeah. So because of the times of lapse, may I end this second session from the second speakers. My sincere apology because of my rude attitude to stop your comment, your concerns, but because of the times, may I continue for the third speakers. And thank you very much, Bu Ervina, and also Bu Fitri, and also Mr. Sarfina Salsabila for your insightful comments. Bu Ervina, you may also add their comments for your paper in your final draft. Yeah, and for your active participations. Now we may enter into the third sessions from the fifth sessions. May I invite Ms. Hikam Alwanullah, LLM, and also Mr. Torik Abdul Aziz Wibowo, who will present the hybrid multi-level constitutional complaint reforming constitutional right protections in Indonesia. Mr. Hikam, Mr. Torik, are you there? Mr. Hikam, Mr. Torik, are you there?
Hello, Professor.
And right, good, thank you. And may I also read Mrs. Mrs. Ramalina Rafayo Mikael Manera, and also Dr. Adya Paramita Prabandari as the first respondent from Asta Research Center from Madagascar, and also Ms. Hani Adani from Indonesian Constitutional Court. Are you there?
Mr. Hani Adhani.
Oh, thank you. Sorry, my sincere apology. All right. So may I invite Mrs. Hikam Ulvanullah LLM and Mr. Torik Abdul Aziz Wibo to present your presentations. Please, floor is yours.
Thank you, Professor. Allow me to doing share screen first.
Yeah, please.
Well, is it clear, Professor? It could be.
It is clear and few, Pak Hikam.
Thank you so much, Professor. Good morning, everyone. Distinguished moderator, professor, and fellow scholars. The respondent, honorable. My name is Hikam Hulwanullah from the Faculty of Law Universitas Negeri Surabaya, and together with my co-author Torik Abdul Aziz Wibo from Universitas Brawijaya, and under the supervision of the Professor Farah Ahmed from the University of Melbourne, we are honored to present our paper titled Hybrid Multi-Level Constitutional Complaint Reforming Constitutional Rights Protection in Indonesia. Well, let me begin with a simple questions. What happens with a simple questions? What happens when a citizen's constitutional right is violated by a government action, but no law directly provides a remedy? This is the reality in Indonesia today, as we know together in this international symposium. Although our constitution guarantees fundamental rights, we do not yet have a constitutional complaint mechanisms that allows individual to directly challenge violations of those rights before the constitutional court. As a result, constitutional rights remain declarative rather than enforceable, and constitutional supremacy becomes limited to abstract judicial review. I have been studying the issue of the constitutional complaint since my undergraduate years, exploring various theories and conceptual framework. During my master's program, instead, I still continue this research and analyze the constitutional court decisions in Polycarpus. As we know, it is one of the big issue decided by the constitutional court, uh, which in my view it is demonstrates the normative organs for establishing a constitutional complaint mechanism in Indonesia. My doctoral research proposal also continue this line of inquiry, focusing on the broader theme of constitutional rights protection. So, however, after carefully observing the development of Indonesian legal and political landscape, I've reached the conclusions that the implementation of a constitutional complaint remain highly challenging in our country. This is not a matter of pessimism, but rather a realistic reflections of our current political and institutional conditions. Therefore, through this paper, we attempt to offer an alternative model of constitutional right protections outside the constitutional court framework. This approach maximizes the rules of various state institutions, both within the judicial and executive branches that already process authority to protect the constitutional rights. We see this as a transnational or transitional step, a pragmatic alternative until a full constitutional complaint mechanism can eventually be realized in the constitutional court. Our approach is inspired by the German model. I think it is always present by all the presenters about German model and South Korea, where the constitutional complaint functions as an ultimate remedy, accessible only after all lower level mechanisms of rights protection have been exhausted. So this idea forms the foundations of what we propose of this paper as the hybrid multi-level constitutional complaint, an integrated model designed to strengthen the protections of constitutional right in Indonesia while maintaining judicial balance and institutional harmony. This paper aims to propose a hybrid multi-level model of the constitutional complaint for Indonesia. We adopt a normative legal research method using a comparative approach, of course, because we need to comparative to design one of the idea and to solve the problem of the constitutional complaint. Analyzing legal doctrine, status, and scholarly work, particularly from Germany and South Korea, which have successfully implemented constitutional complaint systems. Our analysis, by the way, combines three approaches. The first one is statutory approach, reviewing Indonesian legal instrument. The second one is conceptual approach, grounding the idea and the constitutional and rule of law. And the last one is the comparative approach itself, drawing lessons from other jurisdictions. Currently, ladies and gentlemen, Article 24 of the 1945 Constitution limits the constitutional court's authority to abstract review. That is reviewing laws against the constitutions. There is no legal pathway for individuals whose rights are violated by the administrative actions, judicial decisions, or any omissions of public authorities. Institutional and political obstacles also exist. First, because the risk of case overload for the court. Of course, we always hear this realistic fact of the constitutional court, the possible fight between the constitutional court and the Supreme Court, and the last one, the political resistance from the executive and legislative itself. From Germany, we learn the importance of a strict filtering mechanism and procedural discipline. The Verfassung allows individuals to challenge violations of constitutional right, but only after all legal remedies are exhausted, as previously I present. In contrast, South Korea offers a more flexible model that not only reviews individual complaints but also challenges when ordinary courts refuse to review a case's constitutionality. Both systems show that constitutional complaints can serve as a tools for rights protections, judicial dialogue, and even democratic transformations. Building on these models, we propose a hybrid multi-level constitutional complaint for Indonesia. Hybrid means the mechanism combines abstract and concrete review, allowing citizens to challenge both legal norms and specific actions of public authorities. Multi-level means that cases must first be reviewed by lower judicial bodies. That's the keyword of our paper. For instance, the Supreme Court of the Administrative Court, Petun, before the escalated to the constitutional court when the problem of the violations of the individual rights related to the administrative aspect. This structure ensures exhaustions of remedies, promotes judicial dialogue, and prevent case overload at the constitutional court. Normative and institutional design to make this model work, several legal reforms are needed. Constitutional amendment, of course, revisions, legal standing procedures, safeguard, and so on. But for the multi level of constitutional complaint, hybrid multi-level control complaint, we just need a revisions of the regulations as the solutions, brief solutions to solve the problem, and integrated between the institutions to solve the constitutional violations. The system should be inclusive and accessible. That means simple procedures, free legal aid, and electronic filing platform for easier submissions, clear language, assistance by cleric, and opportunities for amicus curiae that previously presents for these presentations. Reforming the protections of the constitutional right is urgent. True constitutional supremacy means that all state actions, not only status, must be reviewable. Implementing the hybrid model can enhance the accountability, prevent abuse of power, and provide remedies for victims of right violations such as wrongful criminalizations, evictions, and environmental degradations. While political will remains the greatest challenges, growing academic support, judicial opponents, and civic awareness show strong institutional and social readiness. To conclude, the absence of the constitutional mechanism in Indonesia reflects a system gap in our constitutional architecture. Learning from Germany and South Korea, we can design a hybrid and multi-level model tailored to our institutional context, balancing accessibility, efficiency, and judicial harmony. Through this reform, Indonesia can finally transform constitutional guarantees into living rights, enforceable and meaningful for every citizen. Thank you very much for your attention. I look forward to your questions and feedback from the respondent. Back to the professor, moderator. Thank you so much.
Mr. Hikam, thank you very much for your punctual presentations for these sessions. And may I give a response to Mr. Ramalina Rafaino Mikia Manitra? Ms. Ramalina? Are you there? Oh, once again, my sincere mistake, my sincere apology, Mr. Ramalina. You already heard Pak Hikam's presentations. Could you please give your response to his presentations, Pak Ramalina?
Okay. First of all, I would like to thank the presenter, Mr. Hikam, for the very insightful. Many presenters have presented the topic in terms of Germany and South Korea as the reference, but you explained well. So my feedback will be that your work is commendable for its helpful and legal reasoning in the effort to connect the theory and practical reform proposal. I've read your paper and I believe that the structured model in which you have proposed is very comprehensive, and you have not only defined what are the points to be addressed by the government of Indonesia, but also how to implement them. However, I have some concerns regarding the operational design of the proposed model. So while the multi-level filtering mechanism involved in the Supreme Court might help prevent overload, it could also create procedural delays or even dilute citizens' direct access to constitutional justice. Because I believe in your model, you use the Supreme Court and other court as well to make as a filtering before coming to the Constitutional Court. So another problem rises here. What about the efficiency and access to justice? Do you think there will be any problem in such issue? And the second question would be that have you considered how political resistance might be mitigated to ensure the model's acceptance within Indonesia's current constitutional framework? That is all. Thank you.
Right. Thank you very much for your insightful comments, Mr. Ramalina. May I invite Mr. Hani Adani?
Okay. Thank you, Chair, Prof. Heri. Thank you for having me at this event. My name is Hani Adani. I work at Constitutional Court of Republic of Indonesia as constitutional registrar and also as student at Faculty of Law Andalas University Padang, West Sumatra. Thank you for the speaker, Brother Hikam Muhammadullah from Universitas Negeri Surabaya. Sorry, Abdul Aziz Wibowo from Universitas Brawijaya, and Ahmad from Faculty of Law, University of Melbourne, who delivered the presentation titled Hybrid Multi-Level Constitutional Complaint Reforming Constitutional Right Protection in Indonesia. I have already truly read the paper, covering at least 30 pages. In the paper, the author not only discussed how the Indonesian Constitutional Court operates, but also compare it with the Constitutional Court of Korea and Germany. In my opinion, the idea of granting constitutional complaint authority to the Indonesian Constitutional Court is not new one. It has been raised since the court establishment in 2003, when it began issuing judicial review decision on status against the Constitution, resulting in 2093 decision to date. It's also been elaborated by former Constitutional Justice Professor Idewa Palaguna in his dissertation. The title is Constitutional Complaint, Legal Remedy for Violation of Citizen Constitutional Right, Study of Constitutional Court Authority in Comparative Perspective, which has been released as a book. The title is Constitutional Complaint. In Indonesia, we call Pengaduan Konstitusional. I consider this dissertation or book essential reading for anyone who is interested in discussing the topic of constitutional complaint in Indonesia. Upon examining the Constitutional Court decision since 2003, we find that numerous judicial review cases have been brought, which strictly speaking do not involve pure norm review, but are more accurately characterize a constitutional complaint. This suggests that the Indonesian public the citizen is already familiar with the concept of constitutional complaint and aware that the court doesn't have the authority to hear such a complaint. As a result, Indonesian justice seeker have been packaging what a truly constitutional complaint case as a judicial review petition. Considering that Indonesia population is nearly 28 million compared to Korea 52 million and Germany 84 million, the idea of granting constitutional complaint power to the Indonesian Constitutional Court must be carefully considered, particularly about the technicality mechanism of submitting a constitutional complaint to the court, as it would be change changing the existing and well-functioning Indonesian legal system. So therefore, in my view, the adoption of constitutional complaint is not necessarily suitable for Indonesia. We should never assume that what worked in other country regarding constitutional complaint mechanism will also be ideal for Indonesia. In my opinion, it will be beneficial to compare strategies for safeguarding citizen constitutional right with those of countries that also have a large population, such as India, China, and States. Regarding the legal issue of basis granting constitutional complaint authority to the Constitutional Court, aside from constitutional amendment, the Indonesia Constitutional Court, as the interpreter of Constitution, could also convey the constitutional message through its decision to the people of Constitutional Assembly, MPR, the Congress, enabling them to carry out such amendment promptly. And also, as initial step, the court could also assume the Supreme Court authority for judicial review of regulation under statute by invalidating provision related to the authority in the Supreme Court law and the judiciary law, thereby ensuring that the Constitutional Court can safeguard legal certainty in the review of all decisions. For example, in the Korea Constitutional Court has also taken this step, and in my opinion, the Indonesia Constitutional Court could also implement a similar measure. That's my brief response to the article. I don't have any question for the speaker. Thank you very much. Hatur nuhun. Terima kasih.
Right. Thank you, Mr. Hani, and also Mr. Ramalina. Once again, my sincere apology for mistakenly attribute yourself. Yeah, my sincere apology. So, Pak Hikam, Mr. Hikam, there are two concerns delivered by the two respondents. You may respond at least for maximum 3 minutes, please.
Okay. Thank you so much, bro, for your time and all the respondent. Thank you for the insightfulness of your comment and respond about my presentations in my paper. But I'm truly very familiar with the conventional concept of the constitutional complaint, especially as discussed by Pak Palguna and Pak Pan Muhammad Faiz. However, in my research, when we read carefully, I do not simply replicate the German model where the Constitutional Court serves as the final gate, once again, final gate after all lower court process have been exhausted. So normally, constitutional complaint when we cited from Germany or the South Korea, it is the final gate after all lower court or process from any branches, either in executive or legislative. Instead, I take the same spirit, same framework, same model, but different perspective. So my idea about the hybrid multi-level constitutional complaint, so it will be held outside of the Constitutional Court by strengthening the role of other state institutions that already functions as the protectors of the fundamental rights. This includes improving the capacity of ordinary court, administrative court, and so on. So the problem about the overload of the cases that previously Mr. Hani Adanis previously said, or what Mr. Ramalani said about the efficiency and access to justice. So this is the shortcut when we waiting for the rules, I mean, like to amend the constitutions, to revisions the act of the Constitutional Court. It's so long because the political debate, the fisticuff political debate. So the problem is when we will implementing, when we maximum to protect the individual rights. So I give a solutions to my paper with hybrid multi-level constitutional complaint, so we can connect it all the institutions or judiciary systems under the constitutional court to protect or to analyze what the object of the constitutional complaint, and when we still not exist about the authority, so we can put, for example, we can enhance the human rights court, specific court under the Supreme Court of Indonesia. So I think that's my idea, not all like what we think about the CC as the final gate of the protection of the control. By the way, Professor, thank you so much for all the insight and response from the respondent. Thank you so much. and happy to hear your comment. Thank you.
Pak Ikam, thank you very much for your response. And ladies and gentlemen, may I conclude this fifth sessions that the issues of the community participations for the constitution really debatable in terms of the whether or not there are legitimate motivations, and also to what extent the idea of this constitutional complaint should be established to be delivered in its authority, and whether the state also already have a blueprint for allocating to the maximum available resources to do such integrations, and whether for the community itself they do know and they understood the idea of these mechanisms to support their advocacy and also adjudications in terms of a better enjoyment of their rights as the citizens. Also, our debate for these sessions might also infringe for the race that potentially emerge when we are talking about this constitutional complaint in Indonesian legal systems, and also whether it also fits with our situation right now and also development for Indonesian futures. So, ladies and gentlemen, I conclude this session by saying thank you very much for your kindness and also your brief presentation to all the speakers and also your fruitful response from the respondents. So I conclude the fifth session by saying thank you very much. Ikan sepat, ikan gabus, makan ikan lele, semakin cepat semakin bagus, kita tidak usah bertele-tele. And I delivered my time to the moderators. Thank you.
Big applause to our incredible speakers, respondents, and also chair for the session 5 of the second day of 7 ICCIS. And now, ladies and gentlemen, all participants of the 7 ICCIS, we're taking break until until 1 p.m. and then the 7 ICCS will resume at 1 p.m. for session 6. Thank you very much.
Firman.
Aduh.
Udah nggak usah. Udah. Halo. Blockchain. Can you hear my voice?
Jadi baterainya mana nih? Gak ada cadangan ya? Diganti aja sekarang daripada. Oh baterai biasa, bukan baterai gitu ya.
Hello, Mr. Yogi. Ama aslında onun şeyini denesek. We will try to...
Okay, the voice is a bit far.
Hello again. This is the microphone that the president will be using during his speech. I think the sound quality is okay, right?
Okay, now it's clear. Thank you.
Okay, thank you. Thank you so much. There is no... maybe we should also open our cameras and try this too.
Okay, sure.
Bir de kamerayı açalım. Videoyu açalım. Okay, this is how it looks.
Okay.
Is it okay right now? Maybe a little bit more.
Ya udah. Yes.
We're making the adjustments. I think it's okay right now.
I think the camera should be moved a bit to the left.
Biraz daha sola değdi ama biraz daha sola belki.
Yeah.
Is it okay
That's
now?
excellent. Yeah.
Okay, thank you so much then.
Okay, you're welcome.
So much. Bye bye.
Bye bye.
Ini kedengaran peserta nggak? Nggak ya?
Kita masih pos.
Assalamualaikum warahmatullahi. Vi, kamu diam aja, Vi.
Ready, lanjut Bu.
Excellency, ladies and gentlemen, all participants, welcome to the last session of the 7 ICCIS. And now I would like to invite Professor Diana from University of Brawijaya to chair the session 6. So, Professor Diana, please.
Thank you. Distinguished guests, His Excellency Chief Justice of Constitutional Court of other countries, colleague and fellow scholar. In this session, last session but not least, we are privileged to have three insightful presentations that approach this topic from different yet complementary perspective. Our first presentation will be delivered by His Excellency Kadir Oskaya. I hope I spell it correctly. The President of Constitutional Court of the Republic of Turkey. And our second presenter is Mr. Nikita Igumnov. I hope I spell your name correctly also. A senior consultant of the Constitutional Court of Russian Federation, who will be delivering a paper entitled Application to the Constitutional Court of the Russian Federation as an instrument of the protection of the constitutional rights and freedom. And our third speaker is His Excellency Mrs. Catherine Mary Savage, a Justice of the High Court of the Republic of South Africa, who will delivering the paper entitled Protecting Marginalized Groups Through Constitutional Complaint as to the South African Constitutional Court. As for the respondents, we have Professor Heribertus Jagatriana from Universitas Gadjah Mada, Mr. Paulus Rudi Calvin Sinaga, and Dr. Bisariadi. Both are from Constitutional Court of the Republic of Indonesia. Similar to the previous session, each presenter will be given 15 minutes to deliver their paper, and then following each presentation, we will have two respondents, each allotted 5 minutes to share. So without further ado, I would like to invite His Excellency Kadir Oskaya to present his paper. The time is yours.
Teşekkür ediyorum. Herkese merhabalar diyorum. Endonezya Cumhuriyeti Anayasa Mahkemesi'nin değerli başkanı ve üyelerini, kıymetli kardeşlerimi, diğer anayasa mahkemelerinin
distinguished presidents and justices of constitutional and supreme courts, esteemed participants, ladies and gentlemen, I would like to extend my warmest.
Forget to announce to participants, since the presentation will be delivered in Turkey, you can have interpretation by pushing a button on your right bottom Zoom, and you can hear in English. Okay, His Excellency, time is yours.
Estağfurullah.
Thank you so much. Let me extend my warmest greetings and highest regards to you all. It's a great pleasure and honor for me to address you today at this online symposium. And I would like to express my sincerest gratitude to Dr. Suhartoyo, Chief Justice of the Constitutional Court of the Republic of Indonesia, and to the honorable justices of the court, and to all those who have contributed to the organization of this meaningful event. Since its inception in 2017, the Indonesian Constitutional Court International Symposium has become an invaluable platform for comparative discussions on constitutional justice. And accordingly, I wish to congratulate the Chief Justice, and I wish for the continued success of this distinguished series of symposia. Allow me to also underline that this year's theme is particularly timely and relevant from the perspective of constitutional justice. The constitutional complaint mechanism provides individuals with a direct means of seeking protection for their fundamental rights and freedoms. In doing so, it transforms constitutional justice from an abstract mechanism into a living and dynamic process that directly touches the lives of individuals. And last month also marked the 13th anniversary of the introduction of the individual application in our court. And as I briefly summarized in my remarks on that occasion, I would like to take this opportunity to share with you the key aspects of our experience with this mechanism, and which has evolved successfully, so to say. Esteemed participants, one of the most significant reforms in the history of Turkish constitutional justice is, without doubt, is the examining of the individual applications. It was realized in 2010 with the amendment. And with this amendment, it provided everyone with the right to apply to the Constitutional Court on the allegation that one of the fundamental rights and freedoms under joint protection of the Constitution and the European Convention on Human Rights has been violated by public authorities. The introduction of the individual application mechanism into our legal system marked the beginning of a new era in the protection of constitutional rights and freedoms. Since the commencement of this mechanism in 2012, the Constitutional Court has been performing this duty with utmost diligence and devotion. Since 2012, nearly 700,000 individual applications have been lodged before our court, of which almost 600,000 have been adjudicated. Excluding the right to trial within a reasonable time, the court has rendered approximately 25,000 violation judgments within this period. Within the scope of individual applications, the Constitutional Court has delivered judgments on a wide range of issues, such as labor-related claims, civil service transfers, disciplinary sanctions, the practices of penal institutions, and some passport cancellations, and thereby developing a comprehensive body of constitutional case law. And the individual application to the Turkish Constitutional Court has also been recognized by the European Court of Human Rights as an effective domestic remedy. Accordingly, applicants are required to exhaust this remedy before lodging an application with the ICCIS. In this context, it's noteworthy that following the introduction of the individual application mechanism, the number of applications lodged from Turkey to the ICCIS, as well as number of judgments finding a violation against Turkey, has significantly decreased. And this decline is, without doubt, a direct consequence of the success and effectiveness of the individual application mechanism. And in this regard, with the individual application, you cannot make and lodge an application to the ICCIS, and the ICCIS does not accept the applications if someone does not apply to the Turkish Constitutional Court before. And in this regard, the individual application before the Constitutional Court of Turkey is considered one of the good practices in the field of human rights adjudication. Approximately 90% of the applications before the Constitutional Court are found inadmissible. Although there might be some differences, similar rates of inadmissibility are also observed in countries where the individual application mechanism has been long institutionalized, such as Spain and Germany. And also we can say that the inadmissibility rate in our court is 60 to 90%, and most of them do not have an examination merits. And with the first examination phase, it's indicated, and then they are eliminated from the system and they are found inadmissible. And I think it's related to the institutionalization of this individual application mechanism. And as I have mentioned before, it's similar in Spain and Germany. However, the rates, the total numbers are not that high when compared with the other countries, but we know that in Germany, for example, there are 60,000 cases, and we know that over 5,000 of them are found inadmissible. So That's why in most of the countries, almost 90% of applications are found inadmissible and only 10% of the applications are examined. We should also underline that this 10% of cases are not always found as a violation. We need to have our examinations in a very meticulous manner. I think in this 10% of rates, we only have 75 to 80% of violation, and only the 3% of them are found as no violation and others are found as violation. And in Turkish Constitutional Court, the total numbers are 100,000, as we mentioned before. And in terms of this period of examination, we can say that we have in total 83,000 cases where we decided on a violation. And these are related to right to a fair trial and right to finalize decisions in a reasonable period. And as we mentioned earlier, we have violations in the terms of the fundamental rights, and they are generally examined on merits. And the applications that are found admissible are examined on the merits. And following this examination on merits, the Constitutional Court may either find a violation of a fundamental right or conclude that no violation has occurred. But as I have mentioned, we have only 3 to 4% of non-violations. So where violation is found and it stems from a judicial decision, the Constitutional Court remits the case to the relevant court for a retrial in order to redress the violation and its consequences. And the relevant court then conducts a new trial in compliance with the reasoning of the court and takes the necessary steps. And in addition, the Constitutional Court may also award compensation to the applicants with the violation decision while sending the outcome of the case to the relevant parties. And in certain circumstances, it may confine itself either to an award of compensation or merely to the finding of a violation. And if there are no requests for compensation, then sometimes, if it's not requested, the compensation cannot be awarded to the applicant. But sometimes, even if there are no requests to a compensation, sometimes the compensation might be ordered for the applicant. And also, if it's related to act and omission of a provision of law, it sends the relevant decision to the Grand National Assembly of Turkey and the relevant court to make the necessary judicial amendments. And with the Grand National Assembly of Turkey, there are some reasonings for that, and it's requested for the Grand National Assembly of Turkey and to make some amendments on that provision. In Turkey, it's not possible to lodge an individual application directly against the provisions of law. And an individual application may only be filed in response to an act or omission of a public authority. That is, in cases where a legal provision has been concretely applied and is alleged to have resulted in a violation of a constitutional right. However, in situations where the Constitutional Court determines that a violation has originated from the law itself, the case file referred for retrial may lead the relevant court to apply to the Constitutional Court for the annulment of the impugned provision. As a result, certain legal provisions have been subjected to constitutionality review and annulled through this indirect process triggered by individual applications. And so we always attach great importance to the case law of the ECHR in this process. And sometimes there are recommendations from the ECHR and other relevant courts to make the applications to the Constitutional Court. And with this constitutionality review, the mechanism of individual application may indirectly bring a legislative provision under constitutionality review. In these cases, the relevant court may indirectly bring, this is kind of a recommendation, and also the Constitutional Court has that case, has been referred to that case, and upon that case, they can give the annulment decision on that impugned provision. And in this regard, through individual application, the Constitutional Court can make this constitutionality review. And I think this shows the transformative effect of the individual application and also the constitutionalization of law through the individual application. And the Constitutional Court has the rights-based approach in its constitutionality review and individual application. And also we can say that the Turkish Constitution in its constitutionality review, it tries to make a rights-based approach, and accordingly we can say that individual application has a substantive effect and transformative effect in terms of its meticulous examination approach. And so the constitutional justice is not an abstract review, but also has an impact, has a solid impact on the societal level. And with the adoption of the individual application mechanism, the Constitutional Court now has a different role, impacting the society directly. And similarly, we can say that with the individual application mechanism, the access of people, individuals to the court has now been enabled. It's much more facilitated and accelerated, and now we can say that it's an effective remedy, effective domestic remedy. And as the Turkish Constitutional Court we're striving to adopt the Constitution and the Constitutional Court and to modernize our court in this regard. Today, one of the most developed functions of the constitutional justice is related to the effectiveness of the individual application and also accelerating the period of constitutionalization of law. It's not just the constitutional justice, but also it includes the other aspects of law, such as tax, such as other fundamental rights and freedoms. And that's why the constitutional justice is transformed by the Turkish Constitutional Court, and we now have a broader framework of the constitutional constitution. So the Turkish Constitutional Court is not about the constitutionality review, and now we are serving as the active practitioner of law. And most of our provisions in the Constitution is related to the effective and proper execution of the Constitutional Court's judgments. And while making rendering decisions, all the relevant courts and relevant institutions in Turkey need to look for the constitution, need to be in conformity with the constitution primarily. And this is required in our country, and this is called as the conformity with the constitution, and it's binding for all the public institutions and relevant court. This principle of conformity in law was all first related to the constitutionality review, but with the introduction of the individual application mechanism, all the relevant courts have started to make their practices in accordance with the Constitution, and this accelerated the discussions about the constitutionalization in law in Turkey. And this requirement and principle, although existed before the individual application, now it has much more impact in terms of individual application. However, we can say that before the individual application mechanism, there were not enough specialists or not a certain institution to examine whether the constitutionality review was executed properly. However, in terms of individual application, the judiciary is now in conformity with the law, and now the Constitutional Court can examine whether these institutions and relevant courts are bound by the law and are bound by the Constitution. This is prescribed by the law, and so this facilitated the process of the constitutionalization of law, especially with the introduction of the individual application mechanism. And now it's not a abstract mechanism, but now it's a very concrete mechanism. And now we can say that, especially as of today, the individual application mechanism in the Turkish judiciary system, when we have a broader outlook in terms of constitutionalism and in terms of constitutional interpretation, paved the way for a synchronization in our case law and in our practices. And since 2012, with the individual application mechanism, has held a strong sense of awareness in terms of constitutional justice. And now when we look at the previous years and when we look at the future, we know that the Constitutional Court has made very major decisions, important decisions, and within this period we have a very meticulous examination, and we are bound by the standards of ICCIS and the principles of ICCIS and principles of other international high courts and institutions. We are always making comparative analysis of important courts and their important case law, and we make deliberations upon them. So in this case, we can that to have successful rates in the individual application mechanism, which we have very high number of applications, we need institutionalization, and we need to provide a very solid system. We need to say that, and as Turkish Constitutional Court, we can say that we have a very successful system, and with the successful system we are executing this system very successfully. And one of the most fundamental results of the individual application is related to the subjective effect of the individual application, which is also called as the inter partes effect. It's very important for us, and if there are any it might be an award of pecuniary and non-pecuniary compensation, and it's so-called redress in our court. And one is the objective effect. It's also called erga omnes effect. And in this regard, all the reasonings, all the principles are related to the whole law order in our country. And it's also related to the awareness of the judges and prosecutors. In one part, we have the constitutional interpretation. On the other hand, we also have the protection of fundamental rights and freedoms. And for example, for public prosecutors' office and relevant courts and their approach to the cases, and we have some principles of these cases and case law. That's why the objective effect of the Constitutional Court's judgments must come into play, and this helps the standardization of the law order in the country. And in our country, it standardizes and strengthens our law order. And in 2025, we had 50,000 cases, and annually we have 80,000 cases annually. We can say that, and we should say that our population is quite high. We have the separation of powers. We have the higher judiciary as the Turkish Constitutional Court, Court of Cassation, and we also have the administrative justice. We have the Council of State, and also the regional courts are included in this division. We also have the Council of the Court of Accounts in terms of the budget of the Grand National Assembly of Turkey and its examination. So we can say that the Turkish Constitutional Court is the final domestic remedy for the applications to be exhausted from other domestic remedies. And also we can say that the individual applications are also related to the culture and specifics, and also the judiciary system of that country. It has specific features like being the defendant or being a lawyer. These are all the factors should be included while making examinations, and also press is related to that process. It has some positive and negative effects. And finally, to summarize, Turkey has a population of 85 million people. And in general, the annual number of our applications are 85,000. Well, I would like to conclude my remarks, but I would also like to mention some things beforehand. The execution of judgments are also quite important. We had some previous order in terms of individual application. We had the transformative effect of the individual application mechanism. However, there are some resistance, especially at the first times of the individual application mechanism. And in our experience, I can say that the ones that are examining the individual application and the ones that are making the application should be very patient, because this is a very complex process. And also the Court of Cassation, Council of State, and Court of Accounts and other public institutions, they need to build a good and solid cooperation between them. And example, with the public prosecutors, chief public prosecutors, and other attorneys needs to have a solid relationship. We need to have a horizontal relationship between them. We need to provide a horizontal cooperation between all those stakeholders. And as I have mentioned earlier, the effective implementation of the constitutional court judgments is not a mere technical matter. All of these features that I have mentioned should be taken into account. And also, we need to have a judiciary culture encompassing all of these specifics of the countries. And we need to have a very healthy dialogue with all of these stakeholders included. We are also working together with the Council of Europe, ICCIS, and other important legal institutions, international institutions, and they are also underlining the importance of cooperating between constitutional courts. I also want to mention that the reasonings are also quite important during the decision-making process, because the concrete examination needs to be done and they need to be solidified. That's why the reasonings are quite important when examining or making decisions, and also it indicates the power of the objective effect of the Constitutional Court's judgments. And in terms of Constitutional Court's judgments, we should be aware that they need to be plain in language, because we are also handling the public and their reactions. And the public needs to know about our cases. It facilitates the whole process, and it also strengthens the relationship that the public has with the Constitutional Court in general. Distinguished fellows, today, constitutional courts are not just about making the constitutionality reviews, but also it has a very important role in protecting the fundamental rights and freedoms. That's why the Constitutional Court has a very major role in strengthening and increasing the public trust to law and constitution in general. And in the constitutional justice, the individual application, also called the constitutional complaint mechanism, has a very significant role. Distinguished fellows, I have lots of things to mention. However, due to the time limitation, I would like to conclude my remarks. And in concluding my remarks, I would like to express my heartfelt wish for the establishment of a just and lasting peace across the world in the shortest possible time, for the end of oppression and violations of human rights and freedoms, particularly in Gaza, in all regions where human dignity is under assault, for the cessation of the inhumane treatment inflicted upon the oppressed and vulnerable, especially women and children, and for the universal triumph of justice without discrimination based on religion, language, or race. This is my sincerest wish in this regard. I sincerely hope that this distinguished symposium will serve as a valuable occasion for the international legal community to foster new avenues of cooperation and to deepen our collective commitment to justice, and above all, to promote a lasting culture of peace throughout the world. I wish all good health, peace, and long life with your loved ones. The humanity is the most important element in the universe. We need to know their value. We need to cherish the value of them. So, on behalf of myself and the justices of the Constitutional Court of the Republic of Turkey, I wish you all good health and a long life with your loved ones. Thank you for your kind attention. And I to send my sincerest regards to the Chief Justice and all of my dearest colleagues in Europe and the people of Indonesia. Thank you so much.
Okay, thank you very much, His Excellency, for a very insightful presentation describing the implementation of individual application mechanism as a reform of the Constitutional Court of Turkey and highlights advantages and effectiveness of having individual application. His Excellency also elaborate number of cases related to individual application, especially violation on fundamental rights and freedom, and importantly detail the mechanism of individual application and how to cope with potential obstacles in implementing such individual application. Now let us turn to our respondents. The respondent will be delivered by Professor Heribertus Jaka Triana. He will deliver his response in 5 minutes. Professor Jaka, the time is yours.
Thank you very much, Ibu Diana. His Excellencies, good afternoon. Greeting, Assalamualaikum warahmatullahi wabarakatuh. First of all, thank you very much for your insightful presentations with regards to the existence of constitutional complaint experience in the Turkish judicial systems. And I underline several important lessons learned from your presentations. First, that the constitutional complaints in the Turkish legal system was really driven by the existence of European Conventions of Human Rights standards to be applicable within the domestic jurisdictions of the Turkish jurisdictions, emphasizing the roles of your institutions, Turkish Constitutional Court, in which it's really gave modalities for the implementations of the constitutional complaint itself. Compare with such a system in our legal system, we are absent such regional human rights mechanisms enshrined within the ASEAN Conventions on Human Rights, which are a very limited authority for such a complaint because we do not have any court resemble to European Court on Human Rights. So this is somehow we learn from your presentations that European human rights standard establishing European Court on Human Rights really give external drivens for the existence in the Turkish legal system for constitutional complaint. So it's quite different in natures in our legal systems. This is my first comment. Second, it's really inspiring that individual complaints in the Turkish Constitutional Court, really a huge number individual complaints. So it means it really needed for the better, management of the cases or individual complaints to be delivered to your institutions. And I think it is really a good, once again, good practices that we should learn on how to, manage this kind of, individual complaints in comparisons with your institutions. Around 70,000 cases already lodged every year, and I think it is unimaginable numbers of individual complaints lodged to your institutions, and without any proper and also a better management of the cases in your institutions, I think it is impossible for us to manage for this kind of complaints. So we really want to learn more about the management of the cases delivered to your institution, and I think we a little bit lack of this kind of internal capacities to manage the cases. Third, and I think you already mentioned that the cases delivered to your institutions already declines for the individual complaints as a constitutional, complaints delivered by individuals. My question is, so the indicators of declining of the numbers of individual complaints, it shows that the human rights protection standard within the Turkish judicial system is may I quote, higher compared with the standard applicable in the European Human Rights Court decision or standards. So I think it is the existence of the margin of appreciations that is already implemented in your institutions. And I think it is a good practices that once again I admire for this achievement. And His Excellency, may I ask one questions to you? If, for example, individual complaints delivered to your institutions, it means it is the last test or threshold determining the exhaustion of local remedies for the lodge or petitions to European Court on Human Rights. So if, for example, your court decides that it is inadmissible, can Turkish individuals may lodge petitions to the European Court on Human Rights directly when Turkey Constitutional Court denied or decided inadmissible for such a complaint? This is my first questions. And the second, if the European Court of Human Rights decides that Turkish government shall behave in accordance to the European Court of Human Rights based upon the petitions or complaint from a Turkish national. If the government does not comply with such decisions, what will be done or what is happening? Thank you very much, His Excellency, and I really expect your comment in that matter. Thank you very much. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam. Thank you very much, Professor Jaka. So His Excellency Prof. Jaka actually raised several questions. One of this, and what if individual complaint was rejected in the Turkey's Constitutional Court? Can it be lodged directly to the human right, and the indicator that so human rights standard is higher compared to European human rights standard? Okay, it's time for you to maybe respond to Prof. Jaka. His Excellency, you can respond to.
Teşekkür ediyorum.
Thank you so much for your questions. First of all, the questions are quite full. Thank you so much for these excellent questions. The first of all, I would like to mention that the Turkish Constitutional Court is always striving to abide by the standards of the European Court of Human Rights and trying to integrate it to the Turkish legal system. We're doing it because the Turkish Constitutional Court is the last domestic remedy before lodging an application to the ICCIS. That's why we need to have these solid standards. And we are trying to prevent violation decisions from the ICCIS. And the second one is in the individual applications, in the adoption of the individual applications, our margin of appreciation is quite limited. And in terms of admissibility and inadmissibility, we're doing it by abiding by the standards of the European Court of Human Rights. I should also say that in this regard, the individual application is an extraordinary remedy, so to say. It's not an ordinary remedy. So the ex officio application, the margin of appreciation in this regard is quite limited. So the examination of the individual application is regarding the quality of the individual application itself. It starts from the application itself. However, the Turkish Constitutional Court has a very wide margin of appreciation in this regard, because we're not always saying that it's inadmissible in the applications that are poorly done, poorly drafted. We don't have that kind of approach. We're always trying to examine whether the allegations are solid, whether the allegations are to be examined, required to be examined. So the Turkish Constitutional Court's margin of appreciation is not that wide. So the margin of appreciation is limited by the Constitutional Court itself. I should mention that firstly. This is related to the periods of the conclusion of the cases. I mean, if you are not exhausting the legal remedies, Turkish Constitutional Court, then it's not acceptable. There are some criteria to be followed. But the other features are related to the appreciation of the Constitutional Court itself. Yes, we have a margin of appreciation, but it's limited in terms of inadmissibility and admissibility criteria. And the complaints of the applicants in terms of the substantive features of the case, they need to put forward concrete allegations in terms of their allegations of violation of a fundamental right and freedom. We need to have substantive information, because we have very unqualified applications, and our rapporteur judges are having challenges with these cases. The most challenging part is the unqualified applications, and also in terms of margin of appreciation, we're always trying to examine the applications. And in terms of your second question, in the admissibility decisions of the Turkish Constitutional Court, or a non-violation decision, there are no differences regarding non-violation decisions or inadmissibility. All of these kinds of decisions can be referred to ICCIS, and in 4 months after notification of the case, they can make an application to the ICCIS about their non-violation or inadmissibility decisions. We have a period of 4 months, and then the application to the ICCIS can be made. And in practice, when we look at the inadmissibility decisions from the Turkish Constitutional Court, when it's referred to the ICCIS, when they make the applications to the ICCIS, we can say that the rate is quite low. For example, we had a meeting, and within the scope of this meeting, as of 2025 March, between ICCIS and Turkish Constitutional Court, we don't have differences in terms of our decisions, in terms of the decisions. Sometimes the rate might be increased because there are some right groups, fundamental right groups in the ICCIS in our court. It might be increased, but in general, we can say that we are coherent in terms of our decisions of non-violation admissibility when compared to ICCIS. I think only 5 or 6% of decisions are differently rendered by the ICCIS. And sometimes there might be differences, but in terms of principle, we don't have exact differences when compared to the rate of violation of ICCIS. And as of now, uh, the applications to the ICCIS from the Turkish Constitutional Court, the pending number of cases are 20,000. And in previous years, before the individual application mechanism, the rates were quite high. Actually, they corresponded to the workload of 2 to 3 years of ECHR before the individual application mechanism. It was very high in terms of rates. So with the individual application mechanism, the number of applications to the ECHR are significantly decreasing. And now with the number of 20,000, and it's related to the coup in 2016 in Turkey. It's related to the coup, the proceedings related to the coup regarding the disputes of the coup. So that's why the numbers are high right now. When we put aside the proceedings related to the coup, then the number of the ECHR lodged from Turkey is quite low. Well, I also lastly mention one thing about when there's a violation decision of the ECHR, for example, when we give non-violation and the ECHR gave violation, in this case, this is different procedure when compared to the violation decision of the Turkish Constitutional Court. When there's a violation decision from the ECHR, there is a different procedure. In Turkish Constitutional Court, we refer the violation decision to the relevant courts or relevant parties, and it's related to the positive law. And it's related to the inferior courts, but the inferior courts here do not have their margin of appreciation. If the Turkish Constitutional Court has given a decision, then the redress should be executed by the relevant court, inferior court. And this is the process that we have. However, if we have a violation decision from the ECHR, then our law order is prescribing a different method. In terms of a violation decision from the ECHR, it's notified to the parties of the case, and then the attorney or the relevant parties, they need to have the violation decision and the other decision which is the subject of the violation. They need to go to that court, and then they order retrial about that allegation of that fundamental rights and freedoms. Orders a retrial, and as I had mentioned earlier, the inferior court in this case, when they have the ECHR's decision, they do not eliminate the previous decision. It also exists. However, the court accepts the retrial, starts to reinvestigate that case, and if the reasonings pave the way for the elimination, pave the way for the redress, and then they order redress and they render the case on redress. I hope I'm able to give the right answers to your questions, but if there are any points that are not understood, then I can provide an answer to you.
Much appreciated, His Excellency. Thank you very much.
Okay. Okay, I'm sure that the participants has questions to be asked, but unfortunately, due to the limited time, we should proceed to the second presenter. However, before ending the first presentation, I would like to thank and deliver my appreciation to His Excellency Kadir Oskaya in presenting such valuable material that can be adopted as lesson learned for Constitutional Court of the Republic of Indonesia. Wassalamualaikum warahmatullahi wabarakatuh. Once again, thank you, His Excellency. Now it is time for us to move to the second presentation. So I would like to invite Mr. Nikita Igumnov, PhD, the senior consultant of the Constitutional Court Russian Federation, to deliver his paper in 15 minutes. Mr. Nikita, the time is yours.
Thank you. First of all, I would like to thank you for the invitation to the conference and for the opportunity to draw your attention to several features of application to the Constitutional Court of Russian Federation as an instrument of protection of constitutional rights and freedoms. As a brief introduction, I would like to say that consideration of constitutional complaints is one of the key powers of the Constitutional Court of Russia, which is the highest judicial body of constitutional supervision according to the Article 125 of the Constitution. The right to file a constitutional complaint is enshrined plainly in the text of the Constitution among the powers of the Constitutional Court of Russian Federation. Within the framework of Russian legal system, in application to the Constitutional Court about violation of constitutional rights is an ultimate form of judicial protection as far as this legal remedy is engaged when all other remedies of protection of rights failed to perform their function and to protect the constitutional rights. It's important also to note that in Russia there is a model of so-called partial constitutional complaint as opposite to constitutional complaint. That means that the subject of the complaint includes laws and other normative acts and not court's decisions or actions of government bodies, agencies, and officials. This is an effective model of separation of functions between ordinary courts, which resolve particular cases on the one hand, and the Constitutional Court of the Russian Federation, which verifies the constitutionality of legal provisions on the other hand. I would like also to note that the Constitutional Court doesn't stand as a revision, doesn't perform a revision functions in regard of the decisions of ordinary courts. The Constitutional Court decides only on whether or not constitutional rights were violated and whether or not the legal provision contradicts to the Constitution. Before the description of the Russian model of constitutional complaint, it is necessary to focus on some statistics. The Constitutional Court of the Russian Federation receives about 13,000 complaints annually, and of these, approximately 10,000 do not meet the formal requirements and reason are returned to the applicants by the Secretariat of the Constitutional Court without consideration on merits. The remaining part of the applications goes through an examination by judges in order to determine whether the applicant's rights have been violated and whether a specific complaint can be or cannot be considered by the Constitutional Court. In such a procedure, complaints are examined by the plenary session of all 11 judges of the Constitutional Court, and approximately 3,000 of complaints out of the total number are declared inadmissible by the ruling of the Constitutional Court. In total, the Constitutional Court of the Russian Federation considers on merits 50 to 60 applications per year, more or less, and most of them are constitutional complaints. According to the Constitution of the Russian Federation, upon complaints on violation of constitutional rights, Constitutional Court of the Russian Federation verifies constitutionality of federal statutes, namely federal laws and federal constitutional laws that are so-called organic laws that are subordinate to the Constitution. Also, Constitutional Court verifies constitutionality of regulations of the President of the Russian Federation, of the Houses of Parliaments, of the Government of the Russian Federation, and verifies constitutionality also of normative acts of the constituent entities of the Russian Federation that have been applied by the court in a particular case if all other domestic judicial remedies have been exhausted. In other words, a complaint on the violation of constitutional rights can be filed about violation of those rights by all major normative acts that may affect constitutional rights and freedoms. Specifying the provisions of the Constitution, the Federal Constitutional Law on the Constitutional Court of the Russian Federation defines some formal requirements for a complaint, such as they need to pay a fee, they need to attach necessary documents and materials, and so on. In addition, this Federal Constitutional Law provides for another condition of admissibility of a complaint, a one-year period for filing it to the Constitutional Court of the Russian Federation. All in all, a constitutional complaint is admissible if first, there are features of violation of the applicant's rights due to the contested legal provision applied during the consideration of a particular case by the court. It means that an ordinary court, on the basis of the contested norm and taken into account the factual circumstances of the case, had resolved the case, and it led to a violation of constitutional rights. Second condition is that all other judicial remedies have been exhausted, which means that before filing a complaint, the applicant appealed all decisions on his court of the highest instance, and for the most part, it's the Supreme Court of the Russian Federation. The third condition is that applicant must file a complaint no later than 1 year after all other judicial remedies have been exhausted. The right to file a constitutional complaint belongs to Russian citizens, foreign citizens, persons without citizenship, organizations of various forms, local governments, human rights commissioners in various fields, for example, human rights commissioner in the financial sphere. Individuals and legal entities file the largest number of complaints, but others, including the High Commissioner for the Human Rights in the Russian Federation, also have filed constitutional complaints several times. As for procedural aspects, a written complaint may be handed in directly to the Constitutional Court or may be filed by mail. It's also possible to apply via internet, by email, and through a special service on the official website of the Constitutional Court. After a complaint is received and registered by the Constitutional Court, it is subjected to a preliminary assessment by the Secretariat of the Constitutional Court for compliance with the formal requirements of the law. If such requirements have not been met, the complaint is returned to the applicant, but he has the right to correct the complaint and send it to the Constitutional Court again. If the formal requirements are met, complaints are referred to the judges for examination to decide whether the constitutional rights of an applicant have been violated or not. At this stage, the complaint may be declared inadmissible by the ruling of the Constitutional Court if there are no signs of the violation of constitutional rights in a particular case, or if other admissibility requirements are not met. It usually takes from 1 to 3 months from the reception of the complaint to the decision on admissibility or inadmissibility of this complaint. The procedure for examining complaints by judges doesn't involve the participation of applicants, and the Constitutional Court examines only the submitted written materials. The refusal to accept the complaint for consideration, or in other words, the ruling on inadmissibility, indicates that the Constitutional Court of the Russian Federation did not find violations of the applicant's rights in his particular case. If the complaint is deemed admissible, it is accepted for consideration on merits, and the Constitutional Court evaluates whether the contested norm corresponds to the Constitution of the Russian Federation and gives it a certain interpretation. The consideration of constitutional complaint on merits takes from 6 to 8 months, more or less, and in recent years, the Constitutional Court of the Russian Federation has been accepting for consideration approximately 60 complaints per year. Consideration of a constitutional complaint may take place in an open hearing in which the positions of the applicant, representatives of the parliament, of the president of the Russian Federation, and other persons are heard in the session of the Constitutional Court. However, most cases today are considered without holding hearings, so parties send their written positions to the Constitutional Court. Constitutional Court assesses them and delivers a decision. If the Constitutional Court of the Russian Federation has considered a complaint on merits and claimed the contested norm unconstitutional, the applicant's particular case where his rights were violated is usually sent for cancelling and new consideration by the ordinary courts. If it's not possible to send the case for new consideration, the applicant is entitled to get a financial compensation. So violated rights can be restored either by cancellation of court decisions and reconsideration of a certain case on the basis of the decision of the Constitutional Court, or by paying a compensation to the applicant in an amount that corresponds to the nature of the violation of his rights. So in legal system of the Russian Federation, constitutional complaint an effective protection of constitutional rights and freedoms. It's deeply entrenched in the Russian legal system and affects not only individual constitutional rights, but the constitutional system of Russia in general. That would be all for now. Thank you for your attention. I would be glad to hear any comments or questions. Thank you.
Okay, thank you so much for the insightful presentation, which outlines the constitutional complaint system as a key tool to protecting a citizen constitutional right under Article 125 of Russian Constitutional. Now we are moving to our first respondent to this presentation, Prof. Jaka. The time is yours.
Thank you very much, Ibu Diana, and Dobodanya, Mr. Nikita. It's nice to meet you in these very wonderful occasions and your insightful presentations. First of all, may I refer to your good practices to deliver constitutional complaint from individuals. If I'm not mistaken, in your practices, around 17,000 cases delivered to your constitutional court for individual complaints. If we make a comparisons to our country, Indonesia, we have around 300 million civilian inhabitants, citizens. So I cannot imagine how, once again, I repeat my questions to you, how the courts in your constitutional court system manage this kind of complaint. A huge number of complaints need a very effective management case system in your constitutional court. How can you manage these issues? Second, once you accept in individual complaint, it means there is a test of the exhaustion of local remedies delivered in your constitutional courts. How can you manage the issues of the threshold for the lapse of exhaustions of local remedies to proceed individual complaints? This is my first comment in your presentations. And my second response to your presentation is that after the decisions delivered to individuals decisions, they have 1 year to do individual complaints to Russian's constitutional courts. Is it effective for 1 year for individual to lodge petitions to the Russian constitutional court? And the last question is that, once again, I refer to the existence of the exhaustions of local remedies. So I think it is a very good, effective practices in your system that the exhaustions of local remedies is a good and effective mechanism to test about the constitutionality of individual complaints. Once again, how you manage with, for example, those who are entitled to lots of petitions to the Russian Constitutional Court, for example, delivered from the commissioners for human rights in certain fields. And I think you need a good coordinations, a good, supervisions to safeguard, Russians human rights standard to be delivered in your constitutional court. And there are my response to your insightful presentations, Mr. And could you please give your feedback to my questions? Thank you very much, Mr. Nikita.
Okay, thank you for the questions. And I just collect the response first, and then Mr. Nikita can respond. So I would like to invite our second respondent, Mr. Paulus from Constitutional Court of Republic of Indonesia. The screen is yours.
Can you hear me? Sorry.
Yes, loud and clear.
So thank you for the opportunity. I'm Paulus Sinaga, Assistant Constitutional Justice from the Constitutional Court of the Republic of Indonesia. I want to convey my response to the presentation delivered by Mr. Nikita Igunov, which has broadened my understanding, particularly regarding the differences between the authorities of the Constitutional Court of Russia and the Constitutional Court of Indonesia. In the Constitution of the Russian Federation, the constitutional complaint mechanism is clearly stipulated in Article 125, Paragraph 4, which allows every individual, including Russian citizens and foreign citizens, and even includes persons without citizenship, has the right to file a petition with the Constitutional Court if they believe their constitutional rights have been violated by the application of a law or legal norm in a specific case. This complaint can only be filed after all ordinary legal remedies have been exhausted, allowing the Russian Constitutional Court to function as an extraordinary legal remedy, ensuring that the law applied in a particular case is in line with the Constitution of the Russian Federation. My opinion is that through this mechanism, the Russian Constitutional Court not only acts as a guardian of the supremacy of the Constitution, but also as a direct protector of the fundamental rights of every individual without discrimination of nationality. Compared to Indonesia, the Indonesian Constitutional Court generally does not have the authority to hear constitutional complaints. However, suppose an Indonesian citizen experiences constitutional harm due to the enactment of a law. In that case, the Indonesian citizen can file a petition for the judicial review to test the constitutionality of the law against the Constitution. The limitation is that the object of judicial review in Constitutional Court is limited to laws. Meanwhile, the Indonesia Supreme Court also has the authority to review subordinate legislation, such as government regulations, presidential regulations, or ministerial regulations. The Supreme Court of Indonesia has the authority to assess whether these subordinate legislation are in accordance with the law. This division creates a dualism in judicial review authority in Indonesia, with the Indonesian Constitutional Court being the guardian of constitutional supremacy, while the Indonesian Supreme Court functions as the guardian of legality. This model contrasts with the Russian Federal Constitution, which consolidating all normative review powers within the Russian Constitutional Court through constitutional complaints and abstract judicial review. In Indonesia, several studies have also argued that the Constitutional Court of Indonesia should adopt constitutional complaint and authority to review all laws, including subordinate legislation, to ensure legal certainty and the protection of all citizens' constitutional rights, including foreign citizens and persons without citizenship. In my opinion, one of the most striking aspects of the Constitutional Complaint Authority held by the Russian Constitutional Court is a direct link between violations of individual rights and the constitutional review of the norms that constitute the source of those violations. The Constitutional Court of the Russian Federation plays an active role in restoring the constitutional rights of individuals who have been harmed. This principle provides an essential lesson for Indonesia, where there are still many violations of constitutional rights that the Constitutional Court of Indonesia cannot handle due to limitations in terms of authority, procedures, and objects of review. I think that concludes my response. I turn the floor to Prof. Diana. Thank you to Mr. Nikita for the presentation.
Okay, thank you so much. So, Mr. Nikita, I think you from Mr. Paulus, I think that's only a response, and Mr. Paulus make comparison between Russian Constitutional Court and Indonesia has and also Russian has the practice of Russian that can be adopted in Indonesia. But from Prof. Jaka, I think there's a question relating to threshold of exhaustion of local remedies interpretation that is accepted by Russian Constitutional Court. Okay, can you respond to the questions and to the opinion of Mr. Paulus? Thank you.
Yes, thank you very much. I'd like to comment upon both responses in general and in some specific aspects. First of all, as for the huge amount of complaints that Constitutional Court annually, of course, it's a big number for 11 constitutional justice. It would be just impossible to examine all of them. And this outlines the role of the Secretariat of the Constitutional Court of legal clerks that help to manage the amount of the constitutional complaints. And most of them are not met with the formal criteria of the constitutional law, so they are returned by the Secretariat of the Constitutional Court, and Constitutional Justice just do not need to evaluate them, the vast majority of this amount. As for the exhaustion of the legal remedies, of course, the requirement of the exhaustion of all other judicial remedies, it was stipulated in the Constitution in 2020. And it's formally prescribed by the Federal Constitutional Law on the Constitutional Court. That requirement means that after a case is adjudicated by ordinary courts, their decisions need to be contested to the Appellate Court, to the Court of Cassation, and finally to the Supreme Court in the most cases. However, the Constitutional Court is empowered to acknowledge that all judicial remedies are exhausted, even if the ordinary court's decisions were not contested to the Supreme Court, to the court of the highest instance on a certain case. It is possible when a court's practice upon interpretation of a certain legal provision is unambiguous and uniform, so the Constitutional Court knows that there is no possibly different way of adjudicating a certain case. So all other judicial remedies may be acknowledged as exhausted. As for 1 year period to file a complaint, it is also one of the admissibility criteria prescribed by the federal constitutional law. On the one hand, this period is long enough to prepare file a proper constitutional complaint. On the other hand, that period means that the decisions of courts on a certain case won't be subject to a possible cancellation for an unlimited period of time. So the parties of that case will be sure in their legal their legal positions, or otherwise a principle of legal certainty would be damaged. As for the coordination between between ordinary courts and constitutional court, of course, there are several forms. Constitutional court sometimes takes part in the Constitutional Court reviews the decisions of the constitutional courts, analyzes them, and gets an information about application of laws by the ordinary courts. In the second response, there was a very striking note about the dualism between the dualism of functions between constitutional court and other courts. As for the contestation of subordinate regulation, which has less power than federal laws, in Russia there is also a similar dualism of functions between constitutional court and Supreme Court in regard of contestation of subordinate regulations, in contestation of bylaws, but the very important feature is that the Constitutional Court assesses the constitutionality of regulation, and ordinary courts, Supreme Court courts, assesses their conformity with law, so their legality criteria of coordination between bylaws and federal legal regulation. That would be, I guess, all. Beside yes, that would be it for my comments. Thank you.
Okay, thank you for insightful presentation, Mr. Nikita. Since we are running out of time now, we're moving on to the last but not least presenter, Mrs. Catherine Marie Savage, the Justice of High Court of the Republic of South Korea, who will be delivering the paper entitling Protecting Marginalized Groups Through Constitutional Complaint, the Access to the South African Constitutional Court. So I would like to invite Mrs. Catherine to deliver the paper in 15 minutes. Mrs. Catherine, the screen is yours.
Thank you very much, and thank you for the invitation sent to the South African Constitutional Court to attend this conference. I send you my warmest greetings and from the African continent, and also warmest greetings on behalf of Chief Justice Mandisa Meyer of the South African Constitutional Court, who unfortunately could not be here today, given that we are in the process in the country of appointing judges, and she is interviewing them this morning. I also send special greetings at the request of the Chief Justice to Chief Justice Sivatoyo of the Indonesian Constitutional Court and the justices of the Constitutional Court of Indonesia and all other judges. My paper today is looking at protecting marginalized groups through constitutional complaint, access to the South African Constitutional Court. I start by saying that South Africa is a country which is plagued by a history of gross human rights violations, with apartheid having been declared a crime against humanity. Yet despite 30 years having elapsed since the end of apartheid and the system of entrenched racial discrimination, it remains one of the most unequal societies in the world. The country's constitution, representing a transition from a past plagued by such violations to a present and future built human dignity, equality, and freedom. Yet 30 years after the end of apartheid, white people continue to own more than 72% of agricultural land in the country, in spite of being less than 10% of the population. And around 5 million people in the country live in informal dwellings, with 10% of South Africans continuing to live in poverty. So much of South Africa's past described as a deeply divided society characterized by strife, conflict, untold suffering, and injustice, and which has generated some of the world's worst human rights violations, remains evident in the daily lives of South Africans almost 30 years after the end of the apartheid era. In spite of this, our Bill of Rights, which affirms values of dignity, equality, and freedom, and our new constitution, which is now not so new, and its promise to unleash transformation, faces significant challenges in the country. The capacity of the state to ensure the realization of fundamental human rights, despite its constitutional commitment to values of accountability, transparency, and responsiveness, is constrained. And it's in this context that the law and legal remedies that we have provided provides a critical role to play in the promotion and realization of these fundamental rights and in holding the state, its functionaries, and officials to account, consistent with principles of justice, equality, and fairness. The constitutional litigation that we have seen has been of critical importance in giving meaning to the progressive realization of socioeconomic rights, and particularly rights of adequate access to housing, and setting the parameters for those facing eviction from housing in the struggle for equality and the move away from poverty in the country. There is still a need for coherent government policy on the issue, but that the Constitution remains a driver in trying to seek redistributive justice, social and economic reform in the country. So the starting point of our constitutional framework then is our Bill of Rights. And in the context of land and property rights, which remain such a pressing issue, the access issues of marginalized groups are most visible. Section 25 of the Property Clause provides protection against the deprivation of property and provides under certain circumstances which are just and equitable for expropriation of land. It also ensures that in section 26 that the right of access to adequate housing is assured, with the state obliged to take reasonable legislative and other measures within its available resources to achieve progressive realization of the right. So national legislation gives further meaning to these as two examples of constitutional rights, and that is in the form of an illegal eviction, Prevention of Illegal Eviction and Unlawful Occupation of Land Act, and also in the extension of Security of Tenure Act for rural occupiers. Litigants then, moving in respect to these two areas, litigants may bring social and economic rights cases to a competent court through a number of pathways, as may other litigants. And Section 38 of South Africa's Constitution provides a broad standing provision which allows several categories of persons to approach competent courts. It includes anyone acting in their own interest, those acting on behalf of another who cannot act in their own name, as a member of or in interest of a group or class of persons, in the public interest, or on behalf of an association acting in the interests of its members. This inclusive standing principle facilitates public interest litigation on behalf of vulnerable and marginalized communities in our country. Direct access to the Constitutional Court is assured in terms of Section 1676 of our Constitution, which allows litigants to apply for direct access when the interests of justice so require it. And this is an important limitation in the context of South African constitutional law. The court has interpreted this provision narrowly, granting direct access to the Constitutional Court only in exceptional circumstances, usually where the matter is urgent or the lower courts cannot offer an immediate remedy. That was seen most recently, or most effectively rather, in the case of Treatment Action Campaign, where the court accepted direct access given the urgency and national importance of a case which concerned the government's restriction on providing the antiretroviral drug nevirapine to HIV-positive mothers. This was important given South Africa's being one of the leaders, unfortunately, in HIV rates in the country. The second way in which one may exercise one's constitutional rights in the country is and take a case to the Constitutional Court is via appeal from the lower courts. And most social and economic rights cases reach the Constitutional Court on appeal from the High Court or the Supreme Court of Appeal. The High Court is recognized as the primary forum for factual inquiries and evidence-based adjudication. It's also recognized in socioeconomic cases as most usefully the court to start cases at once constitutional issues arise, particularly involving legislative validity or the alleged violation of fundamental rights. They may then be appealed to the Constitutional Court. And there's a third way in which parties may approach the South African Constitutional Court, and that is under Section 172 of the Constitution, which allows any High Court or other court which declares legislation or conduct of the state unconstitutional to approach the Constitutional Court for a declaration of confirmation of unconstitutionality. This has occurred in a number of cases, and in the housing rights area occurred in the matter of Grootboom, in which the Constitutional Court confirmed that the state's housing program was constitutionally deficient because it excluded those in desperate need of shelter. So the key features of socioeconomic rights litigation in South Africa are, one, the doctrine of subsidiarity. The first feature is that our courts recognize the doctrine which holds that where legislation has been enacted to give effect to a constitutional right, litigants must first rely on that legislation before invoking the constitutional right directly. This doctrine aims to promote coherence and prevent constitutional arguments from being made unnecessarily when ordinary law provides an adequate framework, subject, of course, to the Constitution. It also allows lower courts to consider the issues which arise in the interpretation of legislation before issues are considered by the Constitutional Court. The second issue which applies and is a key feature of rights litigation in South Africa is the standard of review. And many South Africans have seen this as important in perhaps some of the restrictions which have been seen in socioeconomic rights litigation on the part of the Constitutional Court, given our challenges in dismantling apartheid-era structures and poverty. And they contend that some of the approaches of the South African Constitutional Court to the requirement of reasonableness and the reasonableness standard in judging government policy to have been rather restrictive and limited. Other scholars are saying that model has been usefully applied by the court. But what is of interest is that South Africa is a signatory to the Convention of Economic and Social Rights, and its ratification in the country in 2015 has meant that through the convention, the minimum core standard and approach to socioeconomic rights has been brought into South African law, but that the South African Constitutional Court does not adopt a minimum core standard, using rather the reasonableness standard for government action to be assessed in terms of Section 26 and other socioeconomic rights clauses in the Constitution. And that tension has still to play itself out, that tension between the reasonableness standard and the minimum core provisions included in the convention. What is clear is that the Constitutional Court's jurisprudence has approached socioeconomic rights on the basis that it cannot usurp the functions of the executive or the legislature. And this was stated by one of our first justices, Justice O'Regan, in the case of Mazibuko, where she said that courts are ill-suited to adjudicate upon issues requiring budgetary and technical expertise. And as recognized by some scholars, these findings have prompted us to in their critique of the work of the court to rely on reasonableness in an unnecessarily narrow standard. The third issue which impacts on litigation in this area in our Constitutional Court is the issue of remedies. The Constitutional Court's remedial powers are found in two provisions in the Constitution. One, Section 38, which provides for appropriate relief, and the second in Section 172, which provides for just and equitable orders to be made by the Constitutional Court and other courts in the country. Limited content has been given to this remedial mandate in South Africa, with remedies rarely applied on a case to case-by-case basis. What the provision allows the courts to do is craft innovative remedies suited to the structural needs of, for instance, socio-economic rights, but also other rights violations. And it would benefit perhaps in the Constitutional Court if we started to move towards a more jurisprudential content being given to the issue of relief in expanding the reach of these rights. The forms of relief granted currently include supervisory orders requiring the administration to implement and report on its implementation, structural interdicts which require the administration to act in accordance with directions given by the court, and then also on an occasional basis the award of constitutional damages directly under the provisions of the Constitution where the states failed to provide for the fundamental rights provided in the Bill of Rights. This in recent times has been most visible in areas such as constitutional damages provided where housing has not been provided or to poor and land dwellers, and also in cases where alternative accommodation has not been provided for land occupiers to vindicate their right of access to housing. So in this manner, broad-standing provisions, innovative remedies, and a context-sensitive reasonableness review does allow the court to hold the state to account for socioeconomic rights deprivations and hold the state to account to its obligations under the Bill of Rights, but that the court there are moves afoot to develop jurisprudence in this area further. We have a number of cases in the Constitutional Court which have illustrated how these moves have slowly, on a case-by-case basis, been established. But we have far to go, and we have far to go in the country to dealing with increased societal tensions and increased view that the Constitution does not work in the interests of the majority of the country, with the court criticized for its hands-off approach in the fulfillment of socioeconomic rights and creating a just and equitable society. These social pressures mean that this court must remain alive to the challenges of access to the court, the enforcement of rights, and the need for incremental reforms in the area of remedy. Just to talk shortly about the of access, like countries such as Germany or South Korea and other countries, South Africa has a standalone direct access right under Section 167, as I have mentioned. But one of the difficulties with the court's approach to direct access, unlike other foreign jurisdictions, is that it has treated this remedy as an extraordinary procedure and is only granted by the Constitutional Court in exceptional circumstances, which have been found to exist only when a matter is urgent or of such public importance that delay necessitated by the use of ordinary procedures would prejudice the public interest or prejudice the ends of justice and good government. And the court has said also in certain cases that it must be in the interest of justice for direct access to be granted, that there must be good prospects of success for a case of for direct access to be granted. And this has resulted in the court facing criticism as to this approach adopted. So what is clear is that in granting direct access, the court does not prefer to hear matters without the benefit of a matter having dealt with by the lower courts. It may increasingly have to shift its position in that regard. But given that we are a court only of 11 justices, there is a limit to which we can deal with constitutional issues, plus an expanded jurisdiction which has recently been extended to the court to be the apex court and final court of appeal in all other matters non-constitutional in nature. So many challenges in this regard exist for the country. We also there remain enormous complexities for litigants in both accessing courts, given the cost of courts, the cost of lawyers, and also the limited access to non-governmental organizations and legal aid which might allow them to approach the courts. The complexity of court rules and lack of knowledge of court procedures provides a very significant bar of access to the courts. So those are two areas in which we're looking at how we can relax the rules to enable greater access, and also how we can ensure that we are making legal advice and assistance more readily available for litigants who need to approach the court. What the challenges of this court are to make remedies meaningful, to allow the Constitution constitution to remain a constitution that is that the citizens of the country feel committed to and feel protected by. And given the increased difficulties that we face around in these areas, that has become a very difficult answer to give. That the constitution is not always working in the interests of all of the society, given what the criticisms say some of the way in which the Constitutional Court has limited access to it, and the number of cases which have pressed government to ensure that it engages in a program of long-term social transformation. Instead, what we have seen increasingly is very vast problems of corruption, the stealing of government funds by officials, and the difficulties of our justice system in dealing with that. So by way of conclusion, in South Africa, our shared conception of justice, which was absent under apartheid, started to emerge with the adoption of our constitution. But it has, and whilst our constitution has a clear transformative intent, which is seen in its, particularly in its progressive economic rights clauses, which are unique to many when compared to many constitutions in the world, improving the quality of life of all of our South African citizens and freeing the potential of each of our people remains a very difficult problem for us in the country, and it also poses very significant difficulties for the courts. We are committed as courts, of course, to continue to try and ensure that we make the Constitution a reality and a lived reality for the majority of South Africans. But that in a country in which there are such great disparities, such as ours, with millions of people living in deplorable conditions and in great poverty, with enormously high levels of youth unemployment, 60%. We face a country in which 95% of the people who live in poverty will never break out of that poverty. The role of a constitutional court in that kind of a setting is therefore somewhat unique, and the press upon us to use law as a core tool in the development not only of a constitutional state, but one which is responsive to the issues of the societal issues faced by so many of our citizens, and allow those issues to be properly litigated in our courts, remains a pressing need on the one hand, but one which must be developed slowly and incrementally. In some respects, we cannot jump to the demands of activists that the Constitutional Court may take a more forthright approach. We must always act in accordance with the terms of our Constitution and subject to the rule of law. Thank you very much. I wish everybody very good health, and many thanks for inviting us, the Constitutional Court of South Africa, to participate in this very interesting conference.
Thank you very much for the presentation. His Excellency has analyzed how South African constitutional complaint mechanism and socio-economic rights litigation protect marginalized groups, especially regarding the land and housing right. It also reviewed the landmark of constitutional court cases, showing how doctrines like reasonableness, meaningful engagement, and subsidiarity have shaped transformative constitutionalism to ensure dignity and access to justice. Now, I would like to invite Prof. Jaka to deliver his response to the paper. Prof. Jaka?
Her Excellency, thank you very much for your insightful presentations. Once again, it is really inspiring for our initiations to establish such kinds of mechanisms in our legal system. May I clarify the existence of exceptional circumstances to be used to advocate, the vulnerable, marginalized group, to advocate their rights? Are there any certain criteria to determine whether such exceptional circumstances established to lodge petitions for these mechanisms? This is my first response to your presentation. Whether exceptional circumstances may be interpreted in referring to the victims of the previous apartheid policy in your country. I don't know. May I make these clarifications? This is my first concerns, and my second ones with regards to the reasonableness criteria to be fulfilled. once petitions may lodge their complaints to the courts. Are there any certain criteria to be developed in terms of exercising the criteria of reasonableness, whether only to test the existing regulations per se, and then to be compared with the standard of living of the persons who are categorized as a marginalized group of people or group of individuals on this existence. There are to my response, Her Excellency. Thank you very much for your presentations.
Okay, now I would like to move to the second respondent first, and then can comment on the response. Moving now to Dr. Pisariadi from Indonesian Constitutional Court. The screen is yours. Dr. Pisariadi.
Thank you, Chair.
Okay.
Excellencies, wonderful to see you. Allow me to be straightforward, if I may. I have two questions, actually. I've read your paper. But before, just a quick information for you that the Indonesian Constitutional Court, in terms of comparative approach, also cited, as I remember, two of your decisions. One is on the Grootboom case. It is also involving the housing issues in Indonesia. And the second one is in Doctors for Life cases, which also involve but the issue of lawmaking procedures in Indonesia. So the South African Constitutional Court is very influential in the Indonesian Constitutional Court, actually. So going back to my two questions, actually. I understand your paper was about stretching or focusing on the social economic rights. In terms of constitutional complaint, is there also a big number of the civil and political rights violations and submitted to the South African Constitutional Court? My second question, in terms of remedy, actually, and also in terms of the civil and political rights, you mentioned also in the last part of the presentations about creative and meaningful remedies. Is there any standard for giving remedies? Is there any difference between the remedies for economic social rights and civil and political rights? There is the awards given by the courts. Is that involve some sort of amount of money to the parties who is granted the relief? So that was just my two questions. Thank you.
Okay, thank you so much, the respondents. His Excellencies, I think we have several questions about the criteria of certain circumstances and the reasonableness criteria, and then also a comparative approach to the Grootboom cases, and also the remedies and civil rights, creative and meaningful remedies. Now, would you please comment on this response? Thank you.
Thank you very much. It's always a great honor to feel that our judgments are referred to in other jurisdictions, and I know we rely heavily on the challenges faced elsewhere in the world and in the work of other constitutional courts in researching our judgments, and that is it's very heartwarming to hear that. The exceptional circumstances requirement has really been a source of a very high degree of criticism of our court. The cases which have allowed exceptional circumstances are cases such as the HIV medication case, in which the government refused to roll out nevirapine to pregnant mothers, despite the fact that we have such a high proportion of people living with HIV. And that case in which the court decided that constituted an exceptional circumstance. Another case which the court considered as an exceptional circumstance was the case of Mazibuko, which concerned the water rights and closing access to water when people in very poor communities had not paid water bills. And in that circumstance, the court considered access to water to be a fundamental human right and one which was warranted it hearing the matter on an exceptional basis. But scholars are critical of the court in its failure to expand that direct access requirement, and there's been very little content, in fact, given to what constitutes an exceptional requirement, so much so that, or exceptional circumstances, so much so that we have seen a downtick in litigation of parties seeking direct access to the court. So that has been the negative consequence of not giving meaning to the concept of exceptional circumstances. And then with regards to the reasonableness requirement, what we have said, and we said in Grootboom, was that state measures need to be comprehensive, coherent, coordinated, capable of fulfilling realization of the right, both reasonable, both in their conception and in their implementation. And programs that are rolled out by the government cannot exclude significant segments of the society, and particularly the most vulnerable. The importance of the reasonableness requirements in respect of fundamental rights in the South African Constitution is that certain rights are dealt with as direct rights which are not subject to progressive realization, and others, and the socioeconomic rights, other than the rights of children and education, are not seen as are subject to the reasonableness requirement. So we have two different standards that apply within the Bill of Rights. One, for instance, a right to basic education, but the other a right of access to housing, which must be progressively realized by the state by taking reasonable progressive measures to allow realization of that right. And so that reasonableness standard has been balanced in the context of socioeconomic rights against government policy in almost all circumstances. But there is certainly more content that can be given to the right, and increasingly, given our ratification of the Convention on Social and Economic Rights, it's something that the court is going to and will increasingly have to look at, whether we should give a minimum core we should compel the government to provide a minimum core of content to these rights, including social and economic rights, or whether we can advance the reasonableness criterion to enable us to roll out the rights. And then as far as the question, as far as civil and political rights violations are concerned, one would think that in the South African context that we would see far more civil and political rights violation cases coming to the court. But the irony of the apartheid is that it was a system that was run chiefly through law, and it had for its enforcement a violent police force and army, so there was oppression which surrounded law. But South Africans have a deeply held belief in law, and we are also a country that is a very religious country that is very African adheres to law, cultural communities. African law is a law customary law that is rolled out in every community. And so we believe in legal principles as a nation. No matter which different population group we come from, we have a great belief in law. And I think that what occurred after the passing of the new constitution, which is civil and political rights, is that in large measure South Africans believed then those were their rights, and it was those rights that were then rolled out. So we have seen a few of those cases. We have of course seen some cases, but it's really been where the outer limit of the right has needed to be set, or where, for instance, election rights have needed to be clarified, or the rights of prisoners to vote, for instance, was a case that was brought to our court. And so remedies in the area of civil and political rights have been far less controversial. There have been fewer of them. And really the bulk of the Bill of Rights remedies that we're seeing in the South African context are remedies that occur in relation to more socioeconomic rights, where the challenges are faced around transformation in the country. And then as far as constitutional damages as a remedy is concerned, we are a bifurcated legal system, a system which has both the the common law, Roman Dutch law, given our colonization by both the Dutch and the English, and then also our constitution, and customary African customary law, and increasingly also Muslim personal law, which has also been given meaning in our constitutional context. So what we have is all of these bodies of law which have been found to be part of our one legal system, and in that legal system, the common law provides many and varied remedies, but really as compensation, on a compensatory basis. We compensate under the common law and of delict or tort for patrimonial loss only in certain circumstances where there has been an intrusion into one's dignity or one's person in other ways, and that what we have not had is a damages jurisprudence around constitutional rights in a more positive sense, as opposed to just remediating patrimonial loss, and that really is an area that we're slowly starting to develop into. There have been two recent judgments, Tubachale and also the case of residence, in which the Constitutional Courts in the housing area, the Constitutional Court has given constitutional damages, but there have been various dissenting judgments in those cases, and the law is by no means settled in the area of constitutional damages, and nor has the development of the common in that context been settled as to whether there would be a more positive obligation rather than simply a compensatory obligation to remediate via damages constitutional violations.
Okay, thank you for the comment. We are now arrived at the end of the symposium. So let me sum up the last session of the symposium. This session highlight how Turkey, Russia, and South Africa each use constitutional complaint mechanism to strengthen right protection. Turkey's individual application system enhance access to justice and safeguard fundamental rights, despite implementation challenges. While Russia mechanism allow citizen and institution to contest unconstitutional law and secure remedies like retrial or compensation. And South Africa approach link constitutional complaint with socio-economic rights litigation, advancing justice for marginalized group while confronting deep structural inequality. So together, this experience show that constitutional complaint system are vital to protecting rights, but their effectiveness relies on accessibility, institutional design, and judicial integrity. Lastly, thank you so much for your kind attention, and let us give applause to the speakers. And now I'm handing over the screens to Master of Ceremony. Thank you.
Big applause to our speakers, chair, and respondents of the 6th session of 7 ICCIS. Excellencies, ladies and gentlemen, all participants of the 7 ICCIS, the 6th session will be the last session of our symposium that has been organized since 8 to today, 9 October 2025. And kindly remind you to complete the registrations or the presence link
Daniel, can you
of
chat?
the day 1 and day 2 of our symposium as shows on the Zoom virtual meeting. I will give you some time to scan the QR code as it shows day 1 and day 2 of the symposium. By completing this QR code means to claim the e-certificate that has been provided by the Committee of the Constitutional Court of Indonesia. Later, this e-certificate will be distributed to your registered email after the symposium. Okay, so as closing remarks, I would like to invite Deputy Chief Justice of Constitutional Court of Indonesia, His Excellency Professor Saldi Isra, please.
Thank you, MC. Assalamualaikum warahmatullahi wabarakatuh. Good afternoon and maybe good morning for some locations for participants like in Europe or African. First of all, please allow me to greet and welcome our distinguished counterparts from other constitutional courts. His Excellency Chief Justice Kadir Özkaya, President of the Constitutional Court of Turkey, His Excellency Justice Nopadon Tepitak from the Constitutional Court of the Kingdom of the Thailand, His Excellency Justice Rauf Guliev from the Constitutional Court of the Azerbaijan, Her Excellency Justice Agnes Zin from the Constitutional Court of the Hungary, Her Excellency Justice Catherine Savas from the Constitutional Court of the Republic of South Africa. I would also like to acknowledge the distinguished academics from the international community who have attended this conference, Associate Professor Farah Ahmed from Melbourne University, and Dr. Nikita Igumov from the Constitutional Court of the Russian Federation. I also thanks to the scholars from universities across Indonesia. I see from the agenda, former Justice of the Constitutional Court of Indonesia, Professor Palguna, who is now a lecturer at the University of Udayana, Denpasar, Bali, Professor Muhammad Ali Safaat, and Professor Diana Puspitawati from the University of Brawijaya, Malang, Professor Susi Dwi Haryanti from the University of Pajajaran, Bandung, Professor Heribertus Jakatriana from the University of Gadjah Mada, Yogyakarta, and Mr. Saru Arifin, PhD, University of Negeri Semarang, Jawa Tengah, Central Java, Indonesia. And also to all speakers and participants of this conference, the 7th Indonesia Constitutional Court International Symposium. Ladies and gentlemen, I do understand that all participants have spent 2 long days in these meetings at your respective institutions or places, staring at your computer screens. I'm sure it must have drained your energy and been very exhausting. Therefore, please allow me to be brief with my remarks. This symposium was initiated 7 years ago, and it has become an annual tradition. It is part of our ongoing commitment to promote an academic atmosphere within the Indonesian Constitutional Court. We invite academics and intellectuals to share their views and knowledge for development and improvement of the Constitutional Court. Based on that reason, this year we choose constitutional complaint as the main subject or topic for discussion. The idea comes from the court's interest in adopting such power. In the past few years, the Constitutional Court has received many applications from various petitioners in the form of the constitutional complaint. But these have always been rejected as the Indonesian Constitutional Court does not have such power. The Indonesian Constitution limits the court's power to only deal with judicial review, electoral disputes, conflict among state institutions, dissolution of political parties, and impeachment of the president and or vice president. These limitations, to a certain extent, restrain the court from undertaking its responsibility to safeguard the constitutional rights of citizens. If the court acquires the power to hear constitutional complaint, it would greatly expand citizen access to submit challenges to policies that they believe violate their rights. With this symposium, we need to look abroad. The court needs to find insight and learn from the experiences of other courts which have the experience of the constitutional complaint. Of course, this is still only in early stage. The court needs to look after the pros and cons, the advantages and disadvantages before acquiring the power of the constitutional complaint. During this symposium, we learned that adopting constitutional complaint mechanism will potentially increase the number of cases submitted to the court. This can be seen as an advantage and might be also a disadvantage. The experience of the Hungarian Constitutional Court is well noted. Previously, it accepted direct application of constitutional complaint. But in 2023, the court adjusted its procedure. Direct application are now accepted only if a law directly violates fundamental rights without a preceding judicial decision. And there is no other legal remedy available to address the violation. If these conditions are not met, the complaint must first be submitted to a court of the first instance. Furthermore, at this event, Indonesia Constitutional Court has not only tried to study the pros and cons, we also aim to learn some procedural aspects of that would be valuable for consideration. For instance, we found that our counterpart in Azerbaijan allows access to constitutional complaint even to non-citizens, including stateless persons. This is a significant experience considering the present issue of refugees. The matter is not only about procedure, but also raises a more fundamental question about the scope of constitutional rights. If the Constitutional Court grants access to non-citizens, then the definition of the constitutional right would expand beyond the bond of rights and the duties between the government and its citizens. This would, in effect, create an obligation for the government to protect the constitutional rights of non-citizens in the same way it protects its own citizens. But I will not entertain any of those issues on this occasion. I already promised to be brief with my remarks, a promise that I would like to keep. At the end of the day, I would like to thank Your Excellencies, all speakers, and the participants who attended this symposium. We have enjoyed fruitful discussions. The information that we gain will be very valuable for our objective of considering whether Indonesia should adopt the constitutional complaint or not for the future. Last but not least, with your consent and with gratitude to the Almighty, I declare this symposium officially closed. Thank you. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you very much. So, ladies and gentlemen, excellencies, it officially concludes our 7 ICCIS 2025. On behalf committee of the 7 ICCIS, we personally and sincerely sending our gratitude and appreciations for participating and contributing during these 2 days under the theme Strengthening the Protection of Constitutional Rights through Constitutional Complaints. See you next year on 8 ICCIS. Stay safe. Billahi taufiq wal hidayah. Wassalamualaikum warahmatullahi wabarakatuh.
Di lembar kanvas putih ini, goresan warna-warni bermula dan dimulai, diinspirasi oleh sejarah dan pengalaman yang menjadi guru terbaik. Di antara deru reformasi, juga pekik harapan akan perubahan. Dulu kami lahir, kami tumbuh, merangkak dan berjalan, bahkan kemudian berlari. Tatkala menjadi tumpuan, bagi setiap harapan yang begitu gigih diperjuangkan, kami kokoh, berjejak pada akal sehat dan kejernihan nurani. Tidak terbesit sedikit pun niat untuk angkuh. Lucu, menyombongkan sesuatu yang memang sudah seharusnya dilakukan. Tidak ada kamus untuk jumawa. Untuk apa? Nyatanya, dulu kami pernah jatuh. Pernah terpuruk. Tapi kami segera bangkit, sadar dan belajar akan arti sebuah kepercayaan. Tanpa kepercayaan, rasanya hampa, seperti tanpa makna dan tidak akan bisa berperan apa-apa. Untuk dipercaya, katanya butuh dan harus berani terus terang. Itu sebabnya keterbukaan dikedepankan. Sehingga semua terang benderang. Dengan keterbukaan, kepercayaan itu hadir bersama cinta dan juga rasa hormat. Ya, karena kepercayaan adalah ungkapan cinta dan hormat paling mendasar dan mendalam. Halo?
Halo, dia oke. Minggu depan fix lo pameran ya.
Oh ya? Wah, terima kasih ya atas kepercayaannya.